for somebody born in October. If you're born in April, look for somebody born in September. If you're born in May, look for somebody born in August. And if you're born in June, look for somebody born in July. February, look for somebody born in November. So up we go. Come on, let's get to know each other a little bit better in the room. You can shout each other. Come on, let's find one another in the room. Get to know somebody born in a different month than you. So if you're born in January, look for a December baby. Or if you're born in December, look for a January baby. If you're born in February, look for somebody born in November. If you're born in November, look for somebody born in February. If you're born in March, look for somebody born in October. If you're born in October, look for somebody born in March. And if you're born in April, look for somebody in September. And if you're in September, look for somebody in April, May, August, August, May, June, July, July, June. And if you can hear my voice and you're in the lobby, please come back in. We'd like to start our second session. May. I'll make it easy. Anybody born in July? I was born in June. So if there's anybody born in July, I can keep you company. Huh? Okay, delegates, I hope you've gotten to know somebody from a different month over and above the business interests that we have. Allow me to invite you to take your seats. We would like to begin the second session. So we want to commence our session in the next 2 minutes. So ladies and gentlemen, please take your seats so that we can commence with the second half of our day.
practice and developments in construction across the
Ladies and
continent
gentlemen,
with
please take your seats.
ACL
We are beginning the
initiatives.
second half of our program today. Could everyone please take
First,
their seats
we would like to introduce to you
so that
the
we can commence with
ACL
our second
blog.
half of the day? If you can hear me, please clap once. Clap
The
once.
ACL blog,
Clap twice.
an initiative
Clap once
of
again. Great. Now, allow me, before we begin officially, to have a word from our platinum sponsor. So, ladies and gentlemen, please put your hands together for Claudia O'Brien of HKA.
Good afternoon, everybody. Maybe I should just reset this. Welcome to the graveyard shift this afternoon. On behalf of HKA and my two colleagues in the room, I hope they are both in the room, Stefan, who you would have met yesterday, and Tom Kapapa. Tom, are you in the room? Okay, still outside, but I would like to extend a heartfelt thank you to the ACL, not only for a brilliantly organized event, but also for providing the platform for us to network with our colleagues in the industry as well. I think we can all agree that the discussions we have had so far have been very, very informative, and that last night's social event was very, very enjoyable. So thank you very much for that. As HKA, this is not our first rodeo with the ACL. We have had the pleasure of collaborating with the ACL, not only on events like this one, but also in respect of the very successful training academy that we launched last year in association with the ACL and with King's College. The ACL's dedication to advancing construction law in Africa is truly commendable. And as HKA, we are honored to be associated with such an important and prestigious brand. So just a bit about HKA. Globally, we are known for our multidisciplinary expert specialist services in risk mitigation and dispute resolution within capital projects in the infrastructure sector. We are also known for our forensic accounting and commercial damages and advisory services. One of the initiatives that I would like to highlight is our work in South Africa with one of the major state-owned entities. We've assisted them over the last decade with claims management, dispute resolution, and advisory services at a massive infrastructure build project. We are very proud of what we have been able to contribute to make South Africa a better place for ordinary South Africans to live. And we've done so through helping to undo some of the devastation that was caused by a decade of state capture in South Africa. Now, you might ask how we as HKA did this. And I think, apologies. What we have learned, excuse me, at HKA is that there are many different angles from which to view our world. In addition to our traditional services, we have seen that our skills can also find application to support the aims of investigation and law enforcement agencies, both in South Africa and internationally. And here we had the very interesting experience of working with the FBI on a number of our cases. But working both individually and in collaboration with law enforcement, we have achieved a betterment in the financial position of the particular state-owned entity to the value of approximately 14 billion US dollars. In addition, our efforts also contributed to the arrest and prosecution of a number of very high-profile corrupt individuals in South Africa, and that is something that we're very proud of. But also over the past decade, we've learned a lot of lessons with our clients. The most important thing that we learned is that until we face and deal with the elephant in the room, which is corruption, all the work we are doing to develop our industry and to train our colleagues will be for nothing. We are really excited to now move into a phase of where we are assisting this state-owned entity to implement the lessons that we have learned to help future-proof this state-owned entity against corruption in future. But even more exciting for us is that we would like to extend our lessons that we've learned, not just to other state-owned entities and government departments within South Africa, but also into wider Africa. And we're very happy to say that some African countries have already reached out to us, like Zambia and Botswana, and we are in discussions with them. In HKA Africa, one thing that we are really, really passionate about is growing our local African team. Working with and learning from our top global experts, these guys have become great practitioners in their own right, and we're happy to report that in recent times, they have succeeded in arbitration proceedings against a very big international contractor, and that they've been successful with an all-African or all-South African team, so we're very proud of them. Through our involvement with these initiatives and with the training initiatives, HKA is proud to actively contribute to the advancement of the construction and engineering industries on the continent. To the ACL, thank you once again for a hugely successful and enjoyable event. And to the delegates, thank you very much for coming and for sharing your insights with us. It's been a real pleasure. Thank you very much.
Thank you, Ms. Claudia. Ladies and gentlemen, another round of applause for Claudia. I hope everyone in the room takes the cue, and next year we expect to have at least 5 platinum sponsors, isn't it? So that we can have an address from our sponsors of the day. But we really want to appreciate the great work that HKA has done, and as I was exhorting you, I hope you consider setting up shop here in Nairobi, Kenya. Now, ladies and gentlemen, we want to get into a very interesting panel discussion. It has been spoken of throughout other panels, peppered here and there, but now we want to get into it substantively. We are going to look at ethics and governance in Africa's construction sector. Some of the things that we are hoping to answer today is what are the main ethical and governance issues and challenges in Africa's construction sector? How can construction law promote and enforce the principles and standards of ethics and governance in construction projects and activities, such as integrity, accountability, transparency, and anti-corruption? And those things were highlighted in the panel that we just had right before we went for lunch. So how can construction law empower and protect the rights and interests of different stakeholders and beneficiaries in construction projects, such as workers, communities, and consumers, but more so, even the environment? How can construction law foster a culture of ethics and governance in the construction sector and enhance the reputation and trust of the sector in Africa and beyond? Now, to steer us through this very critical conversation is Yolanda Walker. Now, Yolanda is a partner at global law firm DFW LLP, and she is based in London. Yolanda advises clients on the operations of contracts and the resolution of disputes through negotiation, adjudication, mediation, arbitration, and litigation, and has experience of working with clients through the life cycle of a project to assist in the management of risk and the avoidance of disputes and to help them achieve the best result commercially. Yolanda has expertise in all major standard forms of contract, including JCT, NEC, and FIDIC. She has advised owners and contractors and employers on a variety of projects. These have included buildings, road projects, tunnels, LNG plants, and pipelines. She's a director of Africa Construction Law, a Pan-African thought leadership initiative operating across Africa and in the diaspora to promote construction law and practice in Africa. She regularly presents to various institutions at seminars and at training workshops internationally in the UK. She is also recognized by the Who's Who's Legal and is ranked as a future leader in construction. Ladies and gentlemen, please put your hands together for Director Yolanda Walker. Yolanda shall be joined by 4 co-panelists, and she shall have the privilege of introducing her panel. Joining Yolanda is Mercy Milgo. Ladies and gentlemen, a hand for Mercy Milgo. Following Mercy Milgo shall be Elizabeth Ashun. Ladies and gentlemen, a hand for Elizabeth Ashun. Following Elizabeth shall be Kiara Binta Nkuranga. Ladies and gentlemen, a hand for Kiara. And last but certainly not least, our sponsor, Claudia O'Brien. Ladies and gentlemen, a hand for Claudia O'Brien. Over to you, Yolanda Walker.
Can you hear me? Oh, thank you, Karanu, for that brilliant introduction. And yes, welcome to our panel. I have to say this is probably the most exciting panel because you are very lucky to be trying. I haven't even got there yet. We have 5 women. Why is that so special? Because all of us are experts in our fields, in construction law or otherwise, but also African too. And so for me, this is a very proud moment here. Let's get into what we're going to talk about today, which is ethics and governance in Africa's construction sector. And as Claudia was speaking just now as a sponsor, platinum sponsor, she mentioned this is the elephant in the room. And as Karanu said as well, this has just been peppered throughout the whole conference. So today, this afternoon, really is a really good opportunity to talk about this properly. And I hope that we'll have time at the end for questions and comments because it is such an important factor. But what I would like to say is it's not an issue that's bespoke to Africa. And I think the world sometimes makes us feel like it is an issue that's bespoke to Africa. Corruption pervades the world, and actually different countries deal with it differently such that you think it's not there, but it really is. It might just be a bit more apparent or overt in Africa. So yes, it's not unique. And we hope to look at some of the challenges that are bespoke to Africa and how we can look to overcome them in today's panel. I'd just like to introduce the panel in a bit more detail. I have Mercy Milgo, who is a barrister at Keating Chambers in London. On my left, she specialises in construction and engineering law with a particular focus on fire safety disputes and energy and natural resources. She represents clients in English adjudications and court proceedings and in international arbitrations. Her recent work includes being instructed as part of the council team in a multi-million euro international arbitration concerning the use of a pioneering anaerobic digestion technology at a waste-to-energy plant. She has also just completed a multi-million fire safety adjudication in which she was instructed as sole counsel. Mercy was born and raised in Kenya and has a keen interest in work from Africa and particularly in East Africa. We then have Claudia O'Brien, who is a partner and head of Africa operations with HKA, based in Johannesburg in South Africa. Claudia is an attorney with over 25 years' experience in investigations and forensic sectors, covering both public and private sectors. Before joining HKA, Claudia held a series of senior positions at the Special Investigating Unit and Office of the Auditor General in South Africa. Throughout her career, Claudia has specialized in the strategic and operational planning and execution of high-profile, complex, multidisciplinary, and multi-agency forensic investigation projects. She has a strong background in the investigation of organized crime, commercial crime, corruption, fraud, maladministration, and statutory transgressions. Claudia is also experienced in conducting civil and criminal litigation flowing from such investigations. For the past 5 years, Claudia's focus has been on the investigation of fraud, corruption, and maladministration in the construction industry, with particular emphasis on the infrastructure environment. On my immediate left, I have Elizabeth Ashun. Elizabeth is a dual-qualified solicitor in England and Wales and Ghana, and is a partner in the energy and infrastructure practice at Benti and Chiletza and Akama in Ghana. Elizabeth is a ranked lawyer in infrastructure projects in Global Chambers, Legal 500 and IFLR 1000, and regularly advises clients on infrastructure, real estate development, and finance projects. Elizabeth's clients include government institutions, sponsors, lenders, developers, construction companies, and charities. And last but not least, I have on my right, Kiara Binta. Chiara boasts over 10 years' experience in the construction sector, currently working as the legal manager at DOTT Services Limited, the highest-ranked local contractor in Uganda by PwC. Chiara represents the company in various legal disputes and advises the company on all matters of law associated with routine corporate law, compliance matters, private equity, insurance regulatory compliances, and has expertise and experience in construction law, dispute resolution, and employment practices. Chiara is also a board secretary at the Uganda National Association for Builders, Suppliers, and Engineering Contractors, which she's representing today at ACL. At policy level, through the association, Chiara has co-written a paper that has been presented to the Parliamentary Committee on Infrastructure and which views were incorporated into the local content bill in Uganda. That completes my introductions, and actually I want to get straight into it with Claudia, given her experience in investigating fraud and corruption in the construction industry. So Claudia, over to you. What makes the construction industry so prone to corruption?
Thank you for that introduction, Yolanda. And I think before I jump into answering that question, maybe just 3 points that I wanted to highlight. Firstly, and I'm not sure how many of us know this, but the construction industry is known as either the most or the second most corrupt industry globally. So that's an interesting fact. Secondly, the effect of corruption on infrastructure delivery. In 2015, it was estimated that the cost of corruption to African countries is in the region of $148 billion per year. It also adds to the cost of infrastructure projects and results in poor quality delivery. The third point that I just want to make is that corruption thrives in the dark. So in the place where it's easy to hide price inflation, bribes, etc. Corruption also thrives in chaos, in complexity, and in crisis. So wherever there's uncertainty, corruption is not very far away. And finally, it also thrives in environments where it is the expected thing. That's how business is done, so we're going to do it. So what makes the construction industry so prone to corruption? There's a number of reasons that I'll go through, and I'll try not to be too long, but firstly, it's complex. I think we can all agree on that, and I'm not going to expand too much on that. Secondly, the size and the scale of infrastructure projects. The bigger the project, the more money, the bigger the budgets, the more corruption you're going to find. There's just so much more opportunity for hiding, as I said, hiding cost inflation and bribes, etc. Also, there's a large number of role players involved from many different disciplines, tradesmen, professionals. There's a massively complex transactional chain in relation to all infrastructure projects. Again, the more different contractual relationships you have, with every contractual relationship, there's an opportunity for bribes. Then also government involvement, both in identifying and prioritizing which infrastructure projects should be built, as well as throughout the execution can play a big role. Then also the power of civil servants when it comes to licensing and permits. Obviously, wherever there's a license required, there will be an official wanting a bribe. There's also the culture of secrecy. It's the darkness that I spoke about earlier in the construction industry, in the sense that the issue of real cost is not something that we are too comfortable being transparent about. Also, our venture partners, our subcontractors and our subcontractors, very often there's not much transparency around that. Then finally, or penultimately, poor compliance and detection, and poor enforcement and consequence management. And I think ultimately, to summarize, in an environment or an industry where the payoffs is so big and the chances of being detected, being caught, and being prosecuted and punished is so low, it just makes it worth the while for corrupt people to do their thing.
Thank you, Claudia. Just interestingly, you said that corruption thrives in chaos and uncertainty. In your experience then, what stages of the project delivery cycle are most prone to corruption?
Well, I think what I have experienced is that all phases are very prone to corruption, right from the conceptualization and initiation of projects, where, for instance, politicians would identify a particular project, not because it's the most critical for the people, but because that project would involve a particular contractor that is willing to be bribed and willing to, or rather who is willing to pay a bribe and, then give or receive preferential treatment. Then through the planning and preparation, where feasibility studies are done, here we've seen manipulation with these studies. We have seen falsification of feasibility studies. We've even seen just plain ignoring feasibility studies just because, the aim is to prefer a particular contractor. Also, where specifications are designed, we've all heard about bid or how specifications can be rigged to suit a particular contractor. And also when we look at the procurement strategy, we have have seen in South Africa the effect that it can have when you choose a multi-contracting procurement strategy. So instead of appointing one contractor with accountability, South Africa decided that they wanted to appoint 50 different contractors and then manage all of those contractors and the interfaces between those contractors, which ultimately led to quite a chaotic situation. Where else? Okay, then when it comes to the actual procurement side, I think we all know how prone procurement is to corruption. They say that if corruption is the name, then procurement is the game. So, and all the schemes that take place, obviously within this area as well, is to ensure that a particular contractor wins against all odds. And for me, I think one of the most jarring things that I've seen and the most infuriating is that government officials are willing to give contracts to a contractor who is not qualified to do the job. We've seen instances where critical infrastructure projects have been given to contractors who falsify not only their capabilities, but even their references. So we're busy working on some of those. Then there's also very sophisticated manipulation of technical processes. In one instance, we found that the contractor paid the official with influence over the process to manipulate the program schedule. And as a result, the contractor's price went down and he became the cheapest option and then got the contract. That particular contractor, I'm happy to say we have investigated. They have had to repay approximately $200 million US dollars to the particular SOE, state-owned entity, and they were also fined by the US Security and Exchange Commission on the basis of the evidence that we provided, a further $200 million, of which they repaid $100 million to South Africa on the basis of the work that South Africa did to achieve the outcome. Also, in that instance, some high-level, high-profile individuals, top individuals at the state-owned entity as well as the private company were arrested. There's quite a few other examples, through contracting and so on, but just one that I want to emphasize as well is during the execution phase. Don't make the mistake that there's no corruption during execution. If anything, there's probably as much corruption during execution. And here I'd like to highlight one instance that we found. One of the infrastructure projects we investigated had contractor claims totaling, I'm going to say SA rands now, 230 billion South African rands. And ultimately through the work we did as HKA together with the SIU at the time, that exposure was reduced to 10 billion. So in that instance, we found a 95% overstatement of contractor claims. It's eye-watering and shocking. I think I'm going to stop there. I can carry on all day, but I'm going to stop there.
Which is worrying that you could carry on all day, I think, Claudia. Just listening to that, I could hear you, Chiara, agreeing with Claudia with what she said, most of what she said, and that all of the phases of the project delivery cycle are prone to corruption. In your experience, how does corruption manifest itself in the construction sector?
Thank you, Yolanda. First of all, before I delve into your question, I'm from Uganda, as you said earlier, and Uganda, just like the rest of Africa really, we're grappling with issues of corruption at national, sectoral, and different levels. And last year, we had a conference. It was called the Anti-Corruption Conference. It was funded by the EU, and it was facilitated by Enable Uganda in partnership with the Private Sector Foundation, because we felt that there needed to be some more action and push by the private sector to see that we do something about it, because it's reaching levels where it's prohibitive for people to even invest, to do business, and for companies to function properly in our economy. So as a member of the Association of Contractors, I was part of the steering committee to that conference, and most of what I'm going to share today is what came out of the report that came, because it was dealt with at sectoral level, so there were discussions that were had under the construction sector. So what I'm going to share today is not my views, my opinions, but actually distilled from what was discussed at that conference and the recommendations that were made. So to get to your question, Yolanda, how have we seen corruption manifest itself? It's really, I was agreeing with her because I felt like she's been peeping into my notes, but really it's the same thing. I like to say African problems are similar in wherever you go, whether it's South Africa, East Africa. So it's those deliberate obstacles that are created by the procurement entities, like she was saying. You see that where they're very deliberate to do everything possible to make sure that this work goes to this company, because then there's kickbacks. So they withhold critical information, or they divulge critical information. They manipulate the bidding processes, unrealistic qualifications, because they know that if we put it this high, only one company will be able to go through the process. So you see corruption manifest throughout that process of bidding. In fact, because I sit on the association, many times I am in between. I am both in the regulatory and then private sector a bit. So you see that sometimes complaints come that when they put out the bidding requirements, it's like they just took the experience of a particular company and put that as the requirement, so that when they qualify, it's like, yeah, that's what they wanted. But really, it was leaked to them. So we see, of course, also in this regard, sometimes the donor funding can be weaponized to create an environment where they're also biased as to who will actually end up doing that job. So we see corruption manifest in substandard and poor quality materials. And this is also seen when, because of corruption, she mentioned this as well earlier. Yeah, so these are the specifications that they need, but they collude with the people who should be administering those contracts, the consultants, and then if they want steel of this quality, they pass steel of a lower quality because, I mean, they're in the game, like she said, the procurement game. So then you see that it manifests also in the quality of the materials that are being used. If you're in Uganda, for instance, sometimes there have been incidents where high-rise buildings collapse. That clearly speaks into the quality of material that was used. Did you use the right steel? Did you write the right quantities even? So we see corruption manifest in that regard. Also, in the lack of knowledge in project implementation and capacity. Really, we know construction is complex. Construction is very technical. You need people with the skill, the experience, the knowledge, but you find that because of corruption, people who end up in these positions they lack the qualifications, they lack the experience, and in the end, people getting to that place is because of the isms, I call them the isms of corruption, that open the door to that person to end up in that place. The favoritism, the sectarianism, the tribalism. Somebody ends up being a project manager. They barely have 10 years experience, but because they are known to somebody who can then put them at the helm of that project, what do you expect of such a project, really? Yolanda, are you agreeing or you're eyeballing me like somebody said earlier?
You can continue.
Of course, there's a lack of proper regulation and delayed processes, delays in processing approvals. So all those, like they said, where there is ambiguity, where there is just lack of clarity, you know that it's a manifestation of corruption. Why should somebody put in their request maybe for inspection and there's no reason why there's delays in anything being done, lack of accountability. The big one, the inflation of the bills of quantities. That's terrible. Yeah, in Uganda, we have the Entebbe Expressway. It's about 32 kilometers, the most expensive road in the whole world because of this inflated bills of quantities. When you look at the work done vis-a-vis the price, you're thinking, we would have a highway going through Africa at that price, yeah? But you find, like she said, there's collusions between the public sector players and the private sector players to inflate those, the embezzlement, the kickbacks, and also the other one is the unjustified construction claims, which really is a cousin to the inflated BOQ. So these unjustified claims, we've also seen them where the contractor colludes with the consultant who should be the eye of the employer, and they're just passing claims that when you go through to actually study that claim, there is nothing. There's no document to back that up. There is no data, but they're passing them because they know when it comes around, they will all share in this, in the bounty. So I've seen that those are some of the ways that corruption manifests itself.
You've touched on this already, I think, in terms of the bills of quantity and those being inflated. But how would you say that how would you quantify the costs of corruption in the construction sector? And just to also pick up on the isms, you know, the impact of favoritism, the impact of tribalism, it seems that actually are the costs strictly financial, or are there potentially health and safety costs to, you know, people's lives if you're using poor quality materials? What are the costs to the construction sector?
Most definitely, Yolanda, you talked about the cost of actual human lives. When a building collapses, there's malls that collapse. There are people in those buildings. So how do you quantify the lives that are lost when a building collapses? How do you quantify that? There's really, beyond the cost, that the money, the monetary value, of course, that is obvious, it will be there, but you see the cost of corruption in the poor performances, the poor quality of projects that are delivered, the substandard work that is delivered, and yet they're coming at extremely high costs. You would think that at that cost they would get like a world-class project delivered, but it is substandard, it is poor in its quality. Then there is the delays as well. The cost comes in the fact that a project which could have taken 3 years will take 6 years, will take 8 years. That doesn't make any sense on any scale. So that's also a cost. Of course, you talked about the safety risks, infrastructure failures because of the lack of technical competence, and the collapse of buildings. I said that. The other cost I see is the increase in the cost of infrastructure development, such that the little that we had that could have done so much only does a little, and then you see that slow down the development, because as nations grow, infrastructure is supposed to be at the lead. Yeah, so if the infrastructure development is being slowed down because of that is a cost to everybody. But ultimately, the cost to me, the ordinary Ugandan, I am the one who is paying that cost, yeah? Because these are donor funded. The money is a loan. It is me, the taxes that I pay. So we are bearing the burden. And yet we are not enjoying the services. We are not enjoying the infrastructure. We are not enjoying, but yet we are feeling the tax burden every day. So that is a real cost that the Ugandan person has to bear.
Thank you, Chiara. Elizabeth, you have particular experience of the procurement phase, especially in projects in the public sector. We've heard about how corruption has manifested in the construction industry, and now we've heard also about the costs to, the financial costs and the cost of human lives. How can risks be mitigated at key stages in the delivery of a public construction project?
Thank you, Yolanda, and thank you, ACL, for inviting me to be a speaker today. I'd just like to say that I'm based in Ghana. Ghana is not immune to the issues of corruption. All the issues which my co-panelists have raised are all issues that are applicable to Ghana as well. And I think, as has been mentioned, all of these issues crop up right through the project life cycle. And so I think one of the key ways in which mitigation can be made is through a public investment management system. I know certain countries in Africa has that, Ghana has it too, and I think it would be useful just to go through what that system entails and some of the benefits it can provide in terms of delivering public projects. So Ghana, around 2016, went through a rigorous investment in project infrastructure. They passed some laws relating to financial management and public investment management processes. And generally, the framework provides a framework, so to speak, for the assessment, the evaluation, the implementation and execution of projects. Now, in Ghana, all projects are applicable, providing that the project is over 1 year duration. So it doesn't matter what the source of the funding is, whether it's a solicited or unsolicited project, it will go through the Public Investment Management System. I'll call it PIM system for short, okay? And so the project streamlines the processes, it advises what the authorities need to do, the approval requirements, and the different stages of a project life cycle. So it would start obviously with the project initiation stage. And in order for a project to be implemented, to go through the process, it needs to be part of an entity's framework, medium-term framework. And that framework also has to align with the National Infrastructure Plan, okay? So let's say we have Ministry of Roads, for example. They want to undertake a road project. They would need to initially prepare a concept note. That concept note is just an outline, a summary of what the project is and what the objectives are. If the project concept note is approved, then a pre-feasibility study would need to be undertaken. That generally is based on secondary data and analyzes options that may be available for a project to be undertaken. If the project passes through the pre-feasibility stage, then it would go to full feasibility stage. And there is where, if the procurement entity doesn't have the capacity, normally they would engage a transaction advisor that would be procured through public procurement to basically provide a full feasibility on the project. So that project, the feasibility would consider technical issues, financial, economic viability, legal and regulatory framework for the project, fiscal issues, social and economic and environmental issues, and generally ensuring that the project is viable for the project. Now, if it is approved, then what happens is the Minister of Finance needs to provide a seal of quality. And essentially that seal of quality determines that the project is economically and financially viable. Now, this process takes a long time. And there has been a lot of issues and a lot of kind of disappointment with entities having to go through this long process. But Ghana needed it because we found that there were hardly any bankable projects. And when you don't have a sound investment system, then what happens? You have poor flow of cash for projects. You have poor project selection. You have projects which do not complete. You have lots of cost overruns. You have excessive additional burden on budget, on the annual budget, trying to, try and get a project through. So if the Minister of Finance provides a quality of seal for the project, then it becomes a project which becomes a pipeline project and is incorporated within the PIM system. And then it can then vie for budget and allocation to go through the procurement process. So I think, a lot of issues have been raised in terms of the instances of corruption and bribery, through the life cycle. As has been said, it can be between, the procurement entity and the private party. It could be collusion between private parties so that they can be awarded a contract down the line. And so it is important that governments invest in a PIM system. It does take a long time, but ultimately the idea is to make effective decisions about project pipelines. And I think Ghana is seeing some benefits to that, despite we are going through a very, difficult economic time. But generally, in terms of project pipelines and ministries, departments, and agencies understanding the need for viable project preparation and feasibility and execution, it's been good. I think also contract management is also part of the PIM system. Ideally, the idea is that most ministries, departments, and agencies would use standard documents, which helps to kind of give a position on what government's position is on terms of certain, let's say, financing or allocation of risks. So the Ministry of Finance is going through a process at the moment where contract bidding documents and standard contracts are being tailored on a sector basis, just to help authorities streamline the project process. And then also, in terms of project management, you also need to incorporate a project plan, which has to be incorporated again within the PIM system. And you can have all that. I'm not saying that there is still no bribery or corruption issues, but at least it goes some way to trying to streamline the process. And the regulatory provisions provide defenses. So if a public officer is caught, providing incorrect information on an investment document, or let's say trying to run the procurement process before they've done the pre-investment stage, or generally they haven't complied with the legal and regulatory framework, they would be fined. Now, I personally think the fine is too low. It ranges between $200 to $300. I'm not sure how prohibitive that is, But then, for example, if a public officer is caught and as a result of their actions, the government has incurred financial loss, then that officer would be liable for that.
Okay, thank you. Elizabeth, it's good to see the public sector in Ghana taking those steps to reduce the risk of corruption by implementing more checks and balances to ensure a bankable project. When we talk about risk, though, we do need to consider exposure and who is actually exposed to that risk. So I'd like to ask Mercy, what are the different stakeholders in the construction project, and how would we categorize them?
Thank you, Yolanda. And thanks to the ACL Board of Directors Committee for this opportunity to speak. It's great to be back home and see so many people in attendance. I think that question naturally will generate different answers depending on the project in question. But the one way we can classify them in general terms is to group them into external stakeholders and internal stakeholders, and then to further classify the former, the external stakeholders, into the public and the private stakeholders, and then to further classify the internal group into the supply side and the demand side. So what I will do is I'll start with the external ones on the public side, and those would obviously naturally include the national government, the regulatory agencies, the public agencies. But I think a key one that is perhaps commonly overlooked and can be a key stakeholder, particularly in the African context, and I'll use Kenya as an example, is the local government. And that includes chiefs, it includes assistant chiefs, and they can play a key role not only in highlighting public projects. For example, there's a current, I think that was mentioned in an earlier session, there's a housing project, an affordable housing project going on in Kenya, meant to catalyze growth and development in the local counties. But such local government officials can also play a role in terms of the private projects, and making sure that you have a connection or a link with the local community through this government official. So still staying on external stakeholders, but now turning to the private sector. This would include the local communities, local residents, local landowners, homeowners, but another key one as well that I think at first glance can seem to have little influence on the project, but may actually have an impact, particularly when they employ the media, are environmentalists, conservationists, and other related activists, and this would fall within the private sector. And obviously they would not have a direct influence on the project, but depending on the country, depending on the impact of the media, what they to work together, that can have a significant impact on the project. And as I say, this is particularly important in the African context. Now turning to the internal stakeholders, I think this is one that we are mostly familiar with in terms of the supply side and the demand side. And I'll just start with the supply side. So that would include most of us, contractors, subcontractors, consultants, architects, engineers, and also manufacturers of materials. I think depending on once you get to the very end of the project and there's a dispute litigation, all these parties can be brought in to identify who's responsible if it's a defects claim. On the demand side, I think we've heard a lot about them, the financiers, and they can have such a significant impact, particularly when you consider, I think one of the speakers mentioned the example of they will look at the environmental policies that are in place and whether the project aligns with their own environmental objectives, and they can decide to pull funding, based on reasons like that. So that's a key stakeholder to keep in mind. And also you have the client, but the client's customer as well, particularly if you're a subcontractor and you have back-to-back obligations, such that the obligations of the main contractor applies to you as well. You'll have to consider the client's client or the client's customer. So each of these groups can have an impact on the success of the project. So I think the question, when I was preparing this, I was thinking if I was a contract administrator, if I was a project manager, the question would be, well, I have all these different groups. How can I effectively manage my time, and how can I effectively manage these groups and their various interests to make sure that I'm not dedicating significant time on one group when I should be focusing on the other group, and basically how to achieve that balance. And I think one other way of doing it is to further classify these groups and looking at the extent to which they have an influence on the project and also their interest in the project. And that can be the interest in the success or failure of the project depending on the group. So one sub-classification. The first one is stakeholders who have low influence and high interest on the success of the project. The second group is stakeholders who have a high influence and high interest. The third group is stakeholders who can be classified as having a low influence and a low interest on the success of the project. And the fourth group are those stakeholders who are both have a high influence, however, low interest on the project. So I will briefly discuss these groups in turn and attempt to suggest strategies that you can employ as a PM or as a contract administrator, or sometimes this role falls on the contractor depending on the magnitude of the project. So the first group, low influence and high interest, these stakeholders are usually very helpful in decision making. They have a high interest in the success of the project because they're usually involved in the project, but they have a low influence to intervene or to change things on the project. And what you find that these stakeholders often need formal processes, they need procedures, they need meetings to escalate things. And I think this was touched on one of the sessions on the first day. And sometimes this could be engineers who are involved in the project. This could be subcontractors. This could be the training coordinator in charge of training staff on health and safety. And the key strategy for such a group, in my view, is to proactively inform. So make sure that they're up to date on what's going on in the project, make sure there's collaboration in terms of meetings, because usually they're the ones who are on site, on the ground, and they have a better view in terms of challenges and they can proactively take steps. But as I said, because they have little influence, that's where you come in as the project manager or the contract administrator to make sure that they're informed and also to make sure that you're conveying or relaying those views to those stakeholders that have a high influence on the project. The second group, and this was the high influence and the high interest, this is the most important stakeholder group. They're critical to the project. They must be managed very closely. And usually, like I said, they have a high interest in the project or sometimes in the failure, in the success or the failure of the project, depending on whether they feel their needs are being addressed. And this is usually the client, the employer, financiers, the client's customers. And as I mentioned, in the case of a subcontractor, this would be the main contractor, particularly where you have back-to-back obligations. And then the third group is the low influence and low interest, and this require minimal effort to manage, and I would say they are the least in terms of priority. The strategy for this, before I get to my but, is to monitor them, but I think monitoring does not mean ignoring them, because as I say, depending on the circumstances, these groups can easily turn into a stakeholder group with high influence on the project. So this would be the environmentalists, could be the conservationists, could be the local communities. They usually don't have a high interest in, in the success or failure of the project. They don't have influence as well on the project, but they can, depending on the circumstances. So I would say that whilst the strategy here is to monitor them, and you don't have to proactively inform them on every development of the project, it is still important to make sure that you're not ignoring them and that you're assessing, keeping an eye on the group and assessing whether there are any changes that have been made and finding a way of bringing them with you as you develop the project. And then the last group is the fourth group, high influence and low interest. So they have a high influence on the project, the success or failure of the project, but they have a low interest on the project. And this is usually what I would, in my view, that the national government falls under this group, regulatory agencies, public agencies, and the key strategy for this stakeholder group in terms of managing the group is to keep them satisfied. So you need to keep them satisfied that you've complied with various regulations, keep them satisfied, and this can be wider than the environmental impact as well. But this is slightly different in terms of you're not really liaising, for example, as I said, the local communities, in terms of making sure you're on the same page, but usually you have laws in place and regulations that you must comply with in terms of developing the project. and also to insulate you later on at the end of the project in terms of issues of liability. And as I said, this group, the key strategy is to keep them satisfied, but also another thing is to keep records, records of not just certificates, but any visits, any inspections, because what usually happens is at the end of the project is we had people move on to other projects, then it gets very hard to find these records. But yeah, I think those are the key ones.
Okay, thank you, Mercy. It's interesting how you have categorized them with the interest in the project versus their influence. Chiara, we're running out of time, so if you could keep your response to 2 minutes. How can construction law be used to influence the stakeholders that Mercy's just outlined to fight corruption in the sector?
Thank you, Yolanda. I find that law generally and construction law in particular is a tool that you use. And seeing that the law is a tool, it needs to then be used. It needs to be enforceable. It needs to have the power behind it to be able to achieve that which you need the law to do for you. So in construction law, in the fight against corruption, we need to see stricter penalties for corrupt practices, such that my experience in Uganda, as I believe in the rest of Africa, is that we really do have good laws in place. We have very good laws. There's a saying in Uganda that the best laws and policies are made in Uganda, they're implemented in Rwanda. So we do have these, but we need to see those penalties. So if somebody goes against the norm, what is it? Yesterday somebody said something I don't remember in Swahili, like, who will you tell? What will you do? So there's no consequence or consequence that is actually sound. So we need to see that. We need to see that the law establishes clear guidelines for what is ethical conduct and what is unethical, such that, my sister Claudia said earlier, that where there's ambiguity, where there's darkness, there's any sort of lack of clarity, then corruption will thrive. So can we have clear guidelines that this is ethical and this is unethical? Then I believe we can use the law as a tool to fight corruption in that regard. Also, we need transparency in contracting and procurement processes. We need to provide by law protection for whistleblowers, because this is the people that will shine the light in that darkness. They should be protected by law so that they know that when they come out, there will be no personal consequences to them. We need to have mandatory compliance for companies in regard to lack of corruption and anti-corruption policies. We need to see accountability through auditing and monitoring. We need to provide training and education on anti-corruption practices, such that there's policies, there's laws, there's regulations at different levels, not just at the level of the statute, but going all the way down. We need also laws that allow for collaborative efforts among stakeholders. Many times you find that they're isolated efforts that are not synchronized, and still whatever creates a gap allows for, I think finally, I'll just cut to the last because I need to say that one, effective enforcement and implementation of the laws and regulations that are already in existence. Thank you.
Really exhaustive, thank you. Elizabeth, Chiara just raised the point about public procurement and the need for transparency. What are the key elements or tools, as Chiara mentioned, found within the law to support transparency and integrity of the public procurement process?
Yes, thanks, Yolanda. I mean, generally, if countries have public procurement laws, there will be an initial overriding general principles of transparency and accountability, fairness. The procurement process should also be competitive. And it's important for the law to also be very clear on its applicability, which entities are going to be covered by the procurement law, And if it's in respect of goods, works, services, are there any exclusions? Are there any entities that will not fall within the public procurement law? Sometimes you may find that that may apply to entities that concern themselves with national security issues. But generally for the procurement of goods, works and services, consultancy services, all these processes that are governed and procured by way of public funds, they will fall under public procurement law. Also, there should be clear guidance on the procurement processes. So in terms of publication, of invitations to tender, expressions of interest, the requirements for procurement entities in terms of the projects that they want and the type of information they need from potential bidders. It should be very clear. It should also be publicized so that all persons who are interested in bidding know the precise requirements. I know we're running out of time. In terms of processes for submission of bids, there should be clear guidance on the criteria required for the companies that are submitting their bids, timing for when they need to submit their proposals, their capabilities in terms of their technical and financial capabilities, being able to ensure that they would be able to undertake whatever project is being procured for. You also need to ensure that details as to how the bids are going to be opened and assessed, they also need to be clear in the law. You also need to consider how the bids will be assessed. So is it going to be on quality over cost? Is it just quality? Is it going to be the cheapest? There needs to be clear criteria and qualifications as to how the procurement entity is going to select the selected bidder, excuse me. There should also be provisions for redress. So if there are any complaints or grievance procedures, that should be clear. And also, of course, there has to be accountability for public officials. They need to be trained as to appropriate code of conduct. They need to declare if there are any conflicts of interests. I mean, we had recently, quite surprisingly, in Ghana, the CEO of our public procurement authority was basically dismissed because he was both a shareholder and a director of a company that managed to obtain contracts, whether it's via competitive tendering or single source procurement. Now, he managed to obtain over $1 million through these contracts, and his company was basically selling contracts to other companies. And the importance of policy think tanks and civil society in kind of monitoring procurement projects is so important, because we have a think tank called Imani. They uncovered the situation that he was involved in. And I think what is very important is that beneficial ownership registers need to be incorporated. They may be within countries' companies acts, but what's important is that if beneficial ownership interests are not noted, then you don't really know who the ultimate beneficial owner is of a company. So it is important that public officials, they sign declarations to confirm that they are not conflicted. I know we're running out of time, so I'll leave it there.
Thank you. So transparency, clarity, it seems to be a trend. Mercy, I'll go to you again. We're running out of time, so 2 minutes. From an English law perspective, what role can statutory policies play in empowering those that are stakeholders in this process?
Yes, I'll try to be very quick. So I'll focus more on the end users or the beneficiaries and the health and safety aspect of it. As we've had, there's a cost to corruption, and it's really those people at the very end who face these consequences. It can sometimes lead to loss of lives, loss of property, and drawing from English law and the English framework, one can see that statutory policies can play a key role in protecting the interests of the stakeholders. And I think the most obvious attempt or the most recent example or perfect example is the enactment of the Building Safety Act in 2022, which I'll call the BSA. And this is quite a novel act or novel statute in the UK in terms it creates obligations when none previously existed. And under this, under the BSA, the English courts have the power not only to hold those who were responsible for the defects, to hold them accountable and responsible, but also to bring in associated companies or entities that were not responsible, were not involved in the construction of the project, but as some are associated to the company involved in the construction. And it is quite a wide power in terms of as the claimant, so let's say I'm the resident and I'm bringing this, going to the courts asking for an order to hold that associated company accountable. I don't even need to wait until that underlying liability has been established in terms of with the party responsible. I don't need to wait until the party responsible for those defects has been held accountable. I can apply for what you call an ancillary order or a building liability order to fix those defects. So it's quite a wide power, and we're still getting used to it,
Yes.
I think, in the UK. But in terms of how you can apply it to the African context, and using, again, Kenya as an example, but I wouldn't use fire safety, perhaps maybe the flooding crisis, which has claimed, I think, over 100 lives, sadly claimed over 100 lives. Whether there's scope, whether there's, there is legislation in Kenya, health and safety legislation, but there is a gap in terms of the framework of how we can even impose a wider protection of the end users. And this is something that perhaps can be looked at from the planning stage, particularly in terms of flooding, where usually you're dealing with not just inadequate drainage systems, but poor urban planning. Whether you can have similar legislation to basically govern the process, the construction process from planning to construction, and not just involve the companies responsible, but to think of even associated companies. Now, whether or not that is workable in Kenya, or whether, as I said, we're still getting used to it in London, but I just thought that would probably be one of the ways that statutory policies can play a role.
Thank you. Yeah, so expanding the scope of responsibility beyond the immediate perpetrator could be a possibility. Claudia, how do you think construction law can promote the principles of ethics and governance in the construction sector?
Hi. I'm going to just focus on one thing, just for the sake of brevity. I think we've spoken about the importance of transparency. And I think one of the ways to ensure transparency throughout our processes is in the contract management process. And particularly when it comes to effective document management processes. I think all parties involved, contractors and employers, need to really get back to basics. It's not always rocket science to fix these things. Get back to basics, make sure that the correct documentation is kept, that you are transparent about that, that project progress is correctly recorded, and really just be ethical in your approach in terms of that. That's just one little thing that I'd like to highlight.
Thank you. Chiara, what actions do you think can be taken at sectoral, regional and continental levels to fight corruption? And noting the time.
Thank you, Yolanda. I think most of the things we've been talking about were at a sectoral level, so let me talk a bit about regional and continental. I think at that level we need to harmonize the anti-corruption laws and policies within the region and within, for instance, the East African region and then across Africa. We need to establish regional anti-corruption agencies. For instance, if there is an issue of corruption in Uganda and then you take up, again, somebody from within Uganda to go and investigate it. still chances are they could be corrupted and the end report also will not be reliable. But if we had a regional agency, for instance, in the East African community or an African one from the African Union that then brought a team to investigate that corruption allegation in Uganda, I can trust that report better because those people would then be thought to be more objective. So we need to also think of conducting joint investigations and operations and providing technical assistance and capacity building, also sharing information and technologies and capacities because, for instance, let's say in East Africa, I would say Rwanda is a country that you could say has zero tolerance for corruption. If we could share between Uganda within the rest of East Africa, how is Rwanda doing it? How are they managing to keep corruption so low? They're equally African, the problems we have, they have. So being able to just share that kind of cooperation between us, sharing the best practices and intelligence between us. We have the East African community, we have an anti-corruption desk. Can that desk be empowered to become an agency that can have enforceable laws and power to sanction? South Africa, we know you also have the protocol on fighting corruption. Can we see more linkages, more synchronization so that it's not just a Ugandan problem, but it becomes a regional and continental problem, and we can then think of solving it from that level? Thank you.
Thank you. And quickly, Mercy, on to you. So Chiara mentioned best practices, and ESG is now a term that we're probably all familiar with. The world is becoming more obligated to consider. What can the courts do to help us move towards better ESG and practices?
Thanks, Yolanda. I think the courts can do quite a bit, and I think at the moment there is currently an increasing number of ESG-related cases. And I think one of the most recent ones is the one relating to the claim made against former directors of a Polish energy company for alleged lack of due diligence of a coal power plant investment. And this is particularly important for those in the financial sector as well, because I think it is the first ESG-related case in Europe in which a company's insurers have also been brought in as the defendants in the claim. Quickly as well, there is the landmark 2021 ruling, which those in the ESG and the climate change sector will be well familiar with, where the Dutch courts ordered Shell to slash its greenhouse gas emissions by 45% by 2030 to ensure the company aligned its business plans with the Paris Agreement goals, which you've heard a bit about today. There is an ongoing appeal. I think it was heard in April of this year. And basically Shell have said there's no legal basis for it. It will force it to shrink its business. I'm just summarizing their legal arguments. We expect a decision in the second half of this year. And obviously, regardless of the outcome, I think it is expected that an appeal would make it all the way to the Dutch Supreme Court. But I think it would be quite interesting for companies similar to Shell to, in terms of the outcome, to see whether the courts can actually exercise this power and the extent to which they can make such orders. But as far as I understand, I think Shell is complying with the order pending the appeal.
Thank you, Mercy. We are actually out of time now, but I think we can probably just take one or two questions or comments, if there are any.
Good afternoon. My name is Tunde Shimoyan. It's been a very educative and insightful session, so I want to say a big thank you to all the panelists. It's been very enlightening. I just have a couple of comments, and my comment relates, there are sort of two comments that I have. In terms of public procurement, one of the issues, you've mentioned corruption, but incompetence is actually a bigger problem than corruption. because in a lot of circumstances, the person who's corrupt is actually competent. So they'll find some structure, something that, they can get their upside, whatever from. But for someone that's totally incompetent, the person is totally out of their depth. And that person has no idea, no clue on the impact of what they're doing. So the damage at times is actually bigger than the damage you have from someone that's corrupt. So for a lot of the public enterprises, you find out that in Africa, the appointees, the people heading some of these public enterprises are political appointees who may be totally clueless about infrastructure, construction, projects, all this sort of stuff. So I think we need to find a way to make sure that for these public enterprises in Africa, you have technical people, industry people appointed, instead of situations where you have political appointees and, my party, we've got into power and I need to compensate, the people who basically got me into office. So that's the first comment I have. The second comment I have is in terms of the need for more transparency, and I think I'm going to borrow a concept from, I think my graduate class in securities regulation. I think disclosure. So the more disclosure we have, the more opportunity there is for increased transparency and a reduction of the corruption. And part of this disclosure should be, we've mentioned about the ultimate beneficial holders. That disclosure is required. And I even think, even for these political appointees, because a lot of them, when they get into office, the conflict of interest actually represents a business opportunity to them. They don't actually know that they're conflicted. They don't actually know that what they're doing is wrong. And they go, oh, well, I'm just a shareholder in the company. I'm not actively involved in the company. It's like, hello? So I think increased disclosure in terms of that's a bit more extensive. It's not just, having the advertising in the newspapers and, publishing of the procurement guidelines. I think there needs to be heightened disclosure in the procurement process in Africa. Thank you.
Thank you very much. And any other comments or questions?
Good afternoon. My name is Mary Angawa from Nairobi, Kenya. I'd like to appreciate the wonderful ladies on the podium. Well done, ladies. And this is really a topic that's to my heart. And I really like to appreciate Claudia because you really set the ball rolling. My comment on all this is that we need to put, as Mercy said, legislation in place. In Kenya, we have got very good laws. Uganda, you remember? Very good laws, but we never use them. But slowly and slowly, we're beginning to use them. What we need to do is to put legislation in place. And when we put this legislation in place, if anybody crosses them, at least you've got some kind of net to fall under. If you have political interview, as my brother here was saying, political appointees, Kenya's changed their law with the 2010 constitution, and they said for you to be appointed, you must undergo an interview. I do not see why not. It cannot be trickled down. So that when you're being appointed, you've gone through the interviews, you have been questioned as to your capability, as to your age, as to your way in which you can be able to be actually properly appointed. If you are not properly appointed, then it's there and it stands out. Now, the other concept that I wanted to bring out is this thing of the legislation. Okay, it's one thing you have legislation in place. The other concept is implementation, which has been for very many years Kenyans' weakness in implementing those legislation that are there. We need to get rid of corruption. I do not see why in this construction law conference, you're busy writing contracts and you don't put a budget there for corruption. Just put it. Put it there so that if anybody asks you a question, where did this money go to? Says it went to so-and-so. And let people follow that person up. you know? I really don't see it. But we are hushing everything, quiet, quiet. Let's put it there. And that's what I said yesterday when we had that particular list. Put the concept of corruption. Call a spade by its spade. Thank you.
Thank you. Any more?
Okay, firstly, I must commend the ladies. In fact, one of the things which was actually outstanding is the fact that the panelists and the chair are ladies. So one of the questions I was asking myself is, why are the men missing? The flip side of it is that it doesn't mean that men don't have morals or ethics. Just that somebody found it fit that ladies were better placed to discuss the topic. But firstly, I have to commend you for the good presentation. I missed some few minutes. I wish I was here. But out of what I got, I'll want to make the following comments. And I think a number of you actually spoke to that, that corruption is bad. Firstly, because it compromises on what we call value for money. Where there is corruption, expect that the pricing will be high. And I think our senior there spoke to it. I think it's high time we put a line item for corruption, if at all we are going to do away with corruption. The other thing I'll talk to is the aspect of the effect of corruption on quality and standards. And ultimately, the effect of that is that you compromise on the services, the quality of services. And I think the effects were spoken about. They are dire. You'll be talking about death, short lifespan of the infrastructure, and ultimately, there's never value for money for the government. Let me speak about the Kenyan context. And I think I'll want to take a different route from my senior, Justice Angawa, that Kenya doesn't lack laws to tame or speaking against corruption or ethics. Actually, if anything, the laws are so many that often they are conflicting, and people are just doing what we call cherry picking to look at which law favors corruption or which law is less effective in terms of fighting corruption. And I think we are even seeing it in terms of the decisions we are getting in our courts. So for me, and this is a question which goes both to the panelists or something to reflect about, I've read a book which I really like, written by somebody called Alexander Harvard. And he says that the solution may not necessarily lie in law, but in having what we call virtuous leadership. Show me a leader who is virtuous. And to be honest, I think you better have such a leader and deal with the issues of technical later. I think there's something to discuss surrounding morals, ethics, in terms of not only the leadership, but we people who are actually on the ground. Because often we fight the leaders, but you rarely find CEOs, board of directors, dealing with projects. The roles are delegated. So I'll say that the head doesn't actually rot at the top. You need to address the legs and the main body. And I think that is where we need to play a role as individuals. Personally, I'll tell you that there's a lot of solution to be gotten there than even addressing it at the point of leadership. And of course, it speaks to the kind of people we also expect in terms of delivering these projects. I will tell you, in any typical organization, there is only one CEO. And maximum in Kenya, 12 board of directors. In any project, you find at the very least 24 people involved in that project. So which is stronger? If the 24 are able to speak one language, what is the CEO going to do? Nothing. What is the board going to do? Nothing. So the thing is that there's a solution midstream, there's a solution downwards, there's even a bigger solution upwards, but I think we need to address it, the issue of corruption in the mega projects infrastructure, because it is actually there, we cannot deny that. And we have found ourselves as a country at a point whereby we have to do so many laws which are even working against us. I'll give one typical example in terms of public procurement, whereby before, under our old law, public sector or entities were allowed to actually do what we call correction of errors. And what was the idea behind that? It was to make projects work. Sometimes those correction of errors were actually working for the benefit of the public entities. But I will tell you in Kenya, from 2015, based on the experience for before 20, under the old law, you find that right now, public officials cannot correct any error, even if it works in favor of the public entity. So is the law serving us? I don't think so. I also think so, depending on which side you are sitting on. So I think for me, we need to think a lot more to do with the ethics and the kind of leadership we have, not only at the top level, but even down, in terms of addressing the aspect of ethics and governance in Africa as pertains construction projects. Thank you.
Thank you very much. I think we're out of time now, so thank you.
Ladies and gentlemen, a hand of applause for our all-female panel. I think we can do better than that. And they were addressing such a critical issue because we've been speaking about it from the beginning of this conference, the matter of governance, ethics, integrity, which we all need. And even you can hear from the comments that we're getting from the audience that this is such a timely conversation because we want to move Africa forward, we want to move the continent forward, but we cannot do it if we don't have proper people in place, men and women of integrity. Because as has been said by our Ladies Justice and our friend here, is that it's about the effective implementation of these laws that we have in place. And I liked what was spoken about earlier by the panel about the true cost of corruption, because it's not just about the money, the shillings. How do you value a life that has been lost? How do you do that? How do you value the impact it has on the environment around them? True cost accounting is an emerging field where we don't just look at the pennies and the shillings, we look at the effect on the natural and the environment around which these projects are being done. So we want to see more and more true cost accounting being done. One more time, a round of applause for our panel today. Allow me to invite Diego Duarte de Campos to give our panel a token of appreciation before we retire them. Ladies, if you could just come to the center. Duarte, could you please make your way to the front? Thank you. A hand for him as he comes to the front.
Apologies for not being a lady.
No, just move closer to the center. Okay. We would like to award Mercy Milgo, the first one. Ladies and gentlemen, a hand for Mercy Milgo. Next is going to be Kiara Binta Nkuranga. Ladies and gentlemen, a hand for Kiara. After Kiara, we are having Claudia O'Brien. Ladies and gentlemen, a hand for Claudia. Next shall be Elizabeth Ashun. Ladies and gentlemen, a hand for Elizabeth. And our chair for the panel, Yolanda Walker. Ladies and gentlemen, a hand for Yolanda Walker. You good? All right, so we want to do a photo of all of you together. Just come. We can do the first photo with Duarte within it. Thank you. One more time, a hand for this very informative panel. We were discussing ethics and governance in Africa's construction sector. Now, one thing that did happen yesterday, we did have an awards dinner, for those of you who were here, you remember? And we gave out a lifetime award. And the recipient of that award could not join us. However, he did send a video expressing his appreciation and the honor of being given that award. I would like to invite us to look at the screens to my left and to my right so that we can receive the message from the awardee of the Lifetime Achievement Award. Media team.
Dear colleagues, friends, distinguished guests, speakers, and organizers of the Africa Construction Law Conference 2024 under the theme of Building Resilience in Africa's Construction Sector. It is a privilege to address you all tonight with this recording. Apologies that I'm appearing remotely, but I'm actually in a hearing and I could not be there in person. It is, of course, a privilege and an honor to receive the award by the Africa Construction Law. I will come to that in a moment. But let me first start by saying that the Africa Construction Law is a Pan-African initiative that is quite unique and aimed at promoting thought leadership and ADR in the field of construction law and practice on the continent and beyond. It envisions capacity building and promoting practitioners involved in construction disputes and practice in Africa. The ACL organizes events, trainings, symposia on all aspects of construction law and practice. Its latest event is the event that you are witnessing and living through today, and I believe by your time tomorrow as well. Unfortunately, I can't be there in person, but I'm recording that, as I mentioned, remotely. The event, which is held in the lovely city of Nairobi, marks a great event that has become a landmark on the continent's agenda of world-class events. I know it's an awards night and it's a cause for celebration to all those who have been honored and privileged to receive awards, and to many of those who are in the future going to receive the prestigious awards by Africa Construction Law. Now, in relation to the specific award I'm receiving today, for which I'm overwhelmingly grateful, I'm privileged, and I will simply say that it is a true honor to receive that Lifetime Achievement Award. I had wished to be with you in person, but interestingly enough, I'm in a different jurisdiction, in a major arbitration hearing, in a huge construction case. The hearing was set more than a year ago, and so I can only appear through that recording because the hearings are actually taking place all through past week and this week. I have to say that although I regret my inability to be there with you in person, I am deeply grateful for the award and the honor bestowed upon me by the ACL. I would like to think that despite this award being labeled as a Lifetime Achievement Award, that I have more years to work and to contribute. Traditionally, Lifetime Achievements Awards are given to people coming towards the end of their career. I think I still have some years to contribute more. So I would take this graciously and see it as a very kind award that relates to achievements that others perceive that have already have made, and hopefully those that I would like to believe that I can still make in the future. On the ACL website, when I was informed very recently that I would be honored with that award, I decided to check how did I actually land that award and what is the criteria. And the description on the ACL website regarding that Lifetime Achievement Award, which is not based on application at all, is recognizing a professional who over the course of the individual's career has made significant contributions to the development and practice of construction in Africa. The award reflects the nominees' outstanding leadership and sustained contributions, achievements, and legacy in the sector. I can only aspire to say that if a fraction of that applies to me, then I'm very grateful and honored and privileged to be seen as such. I'm doing my best, not only on a personal level, but to assist colleagues, friends, brothers, sisters on the continent and beyond across the globe to achieve and attain their full potential in the world of dispute resolution. I firmly believe that capacity building, thought leadership, and mentoring of our younger colleagues marks a future for our beloved field in the field of dispute resolution and construction, law and practice specifically. Now, I wholeheartedly
It's all right. We're good to go. But ladies and gentlemen, please let's appreciate Dr. Wahab and honor him for his achievements. Now, allow me, in the interest of time, to transition into the next panel. We are going to be having a panel on construction arbitration claims, a teaching session from leading construction and industry practitioners. So this is basically what happens on the ground. So this panel discussion is on construction arbitration and enforcement claims, views from Africa's top in-house and private practice practitioners, as well as leading technical experts. This session will provide key guidance and focus on 1, the foundation of construction projects, 2, contractors' claims, remedies and reliefs, 3, employers' claims and remedies, and lastly, dispute resolution and expert advice. Ladies and gentlemen, to lead this particular conversation is Professor Renato Nazin, that is a Director, Center of Construction Law, King's College London in the United Kingdom. He is an experienced arbitrator, chair, sole arbitrator, co-arbitrator, and emergency arbitrator and counsel in international arbitration with varied industry knowledge, not only in construction, oil and gas, and infrastructure, but many, many more, including mergers and acquisitions, IT, and digital pharmaceuticals and distribution. He is dually a qualified English solicitor and Italian advocate and has worked in arbitrations in Europe. He has been a visiting professor at the University of Turin, the University of Zurich, and FGV of São Paulo, Brazil. He holds a PhD from the University of London and a PhD from the University of Milan. Ladies and gentlemen, please put your hands together for Professor Renato. Professor Renato shall be joined by his 4 co-panelists, whom he shall invite himself. He shall introduce himself. That is Dr. Bernd Ehrle. Let's put our hands together for Dr. Bernd. Following Dr. Bernd shall be Rajat Singla. Ladies and gentlemen, our hands for Rajat Singla. Very quickly followed by Jacqueline Waihenya. Ladies and gentlemen, a hand for Jacqueline Waihenya. And lastly, we shall be joined by Paul Ngotho. Ladies and gentlemen, a hand for Paul Ngotho. Over to you, Professor.
Thank you very much. It's a very long biography that was used to introduce me. It was cut short before saying that I have arbitrated not only in Europe, but also, of course, in Africa and in Asia and in the Middle East. I thought that Africa was the relevant bit that was omitted. But thank you very much for the introduction, and thank you very much for inviting me for the 3rd time to the ACL conference. I would like to congratulate ACL and the organizers and ACL directors for the great achievement that ACL has obtained over a relatively short period of time, being really today the leading construction law platform and association in Africa, championing capacity building, and knowledge dissemination and knowledge generation in Africa. So I'm very pleased to chair this panel, and I'll introduce very, very briefly the speakers. They have already been named, but nevertheless, first of all, Dr. Bernd Ehle, who is a partner at LaLive in Geneva in Switzerland, who specializes in international arbitration, has acted as arbitrator of counsel on more than 100 high-stake arbitrations all over the world, including Africa, and of course is a member of the advisory board of, a fellow member of the advisory board of Africa Construction Law. Secondly, Rajat Singla, associate partner at Macy in Dubai. He is a civil engineer with a Master of Laws in dispute resolution from the University of New South Wales in Australia, and he acts as a consultant and as an expert specializing in particular in delay analysis, contract and claims management, and of course dispute resolution, in line with the very topic of this panel. Jacqueline Waihenia, on my right-hand side, she's the chair of the Chartered Institute of Arbitrators branch in Kenya, and she's a chartered arbitrator and a chartered mediator. And among other things, I just wanted to highlight 2 prizes she was awarded. First of all, Africa Women Leaders Award in 2023, and Africa Influential Female Lawyers 2022. And last but not least, we have Paul Ngoto, who is the managing partner at Ngoto Arbitration Chambers here in Nairobi in Kenya. He's a chartered arbitrator and essentially works as a full-time dispute resolver, so as arbitrator, mediator, and dispute board member, and so on. So you have already heard what the panel is going to be about. The first a point on the program that you can see is foundation of construction projects. We thought it was a bit metaphysical, so we will start instead on a more practical level with contractors' claims, remedies, and relief. So looking at that from the point of view of the contractor. And first of all, I would like to ask Bernd, if I may, to take the lead and to talk to us about his experience from a practical perspective of what are the issues faced by contractors, particularly in Africa. Bernd, over to you.
Thank you. Thank you, Renato. Good afternoon, everyone. It's a pleasure to be back, and I'm grateful to the ACL for giving me this opportunity, and I very much look forward to our discussion. As Renato said, I will first talk about contractors' claims, and it's obviously impossible to cover that broad topic in a few minutes, so I have picked 3 different areas that I believe are of interest in the context of construction projects in Africa. One of them is dancing with disruptions. The second one is dealing with difficulties to access construction sites. And the third one is efficiently addressing high volumes of low-value claims in construction arbitration. So the first one, dancing with disruptions. We heard a lot yesterday about the challenges that contractors have faced in recent years and are still facing today. And I like to refer to these as the 4 C's: climate, COVID, conflict, and cash, meaning inflation, price increases, and cash flow in general. And I don't want to rehash things that were said yesterday, but focus on the contractor's ability to effectively deal with and adapt to unforeseen global events that disrupt their operations, just like the 4 C's I just mentioned. So to successfully manage these disruptions, contractors need to develop resilience, which is the topic of this conference, and flexibility in their strategies and operations. And following on from yesterday's discussion, what I have seen on a recent ongoing construction project that I'm following is that strong leadership and transparency can make a real difference. And what I mean is, in that case, on that project, the contractor In addition to keeping detailed and comprehensive records of any delays and disruptions, such as timesheets, also opted for very regular, clear and transparent communication with the employer and with all the stakeholders, so that everybody is informed of the potential risks and the ongoing disruptions. And despite the complexity of the situation with parallel causes, parallel disruptions and multiple crises, this did enable the parties to be fully informed of the situation and also enabled them to make quick, informed decisions and even adapt the contract where that was necessary. And so by applying this strategy of transparency and communications and strong leadership, the contractors can better dance with disruptions, protect their interests, and turn potential crises into opportunities. The second point I would like to address seems to be quite Africa-specific, namely the difficulties that contractors sometimes face in gaining full or timely access to the construction sites. And this was actually cited by the ICC in last year's Industry Insights issue on construction arbitration as one of the main causes of claims and disputes in Africa, a little bit more so than in other parts of the world. And the reasons for restrictive access to construction sites in Africa can be obviously many and varied. And I want to mention three here today and give some practical examples to illustrate these difficulties. So the first one is local resistance and community issues. In some cases, local communities resist construction projects because they're concerned about displacement or about environmental impacts or lack of consultation. In South Africa, for example, community protests have delayed projects like the Sholobeni Mineral Sands project in the Eastern Cape. And here in Kenya, the construction of the Mombasa-Nairobi Standard Gauge Railway has been delayed due to land acquisition issues, which is probably well known to many of you in the room, with negotiations with landowners and legal battles over compensation taking up significant time. So that's one reason for delayed access to construction sites. Another one is infrastructure and transportation issues, especially for projects in remote areas such as mining sites or hydropower plants. The road network can be a real challenge, especially in the rainy season, and the roads can even be impassable and leading to significant delays in the transport of materials and equipment to the construction sites. Sometimes the roads also have to be built first. In Ethiopia, for example, the construction of the Grand Ethiopian Renaissance Dam experienced delays due to logistical problems in transporting material to the remote construction site and also navigating the difficult terrain of the Blue Nile region. And the third reason for difficult access to construction sites are bureaucratic hurdles and regulatory delays. So obtaining the necessary permits can be a lengthy process in some countries due to bureaucratic hurdles that can delay the start of a project, or the import of construction materials and equipment can be delayed due to customs procedures. And one example for that is the Lekki Deep Sea Port in Nigeria, where the access to the site was complicated by delays in permits and environmental clearances, as well as congestion at the port of Lagos. So these three examples, there are probably many more, and it would be interesting to hear later on from the audience if you have other experiences. But what can the contractors do in such a situation? Obviously, they have or might have a claim for extension of time. They might have a claim for compensation for additional mobilization costs. But if they really want to address and take the bull by the horns, they can try to themselves coordinate and work with the owner to ensure compliance with legal and safety requirements that sometimes delay the access to the site. They can possibly arrange for insurance coverage, including general liability insurance and workers' compensation, and the required performance and payment bonds. And they can also try to themselves engage with the local community and the authorities to even the path to access to the construction site. So maybe if we have time later on, it would be interesting to hear from the audience if you have other experiences. And the third topic I wanted to briefly address in the context of contractors' claims is how to efficiently address high volumes of low value claims in construction arbitration. So some disputes, as you know, involve high volumes of low value claims. For example, multiple minor variations. And when considered in isolation, all of these small claims have limited monetary consequence. But on the other hand, when gathered and considered together across the whole project, the cumulative value can be quite significant. But if each of these small value claims is addressed in the same way as large value claims in a construction arbitration, then there's a risk of disproportionate costs. You cannot take evidence for every little variation. So the parties and the tribunal need to find adequate tools and techniques to ensure that such claims are addressed in a streamlined and cost-efficient manner. And there's some room for pragmatism here and for creativity. And I would like to give a few examples from practice. One of them is a so-called Scott schedule. Some of you may be familiar with that, which is like a red phone schedule in document production arbitration. You have a table setting out for each of the little claims, low-value claims, the evidence and the legal basis, and it's easier for the tribunal then to have a single convenient document to deal with those claims. Another technique is sampling, statistical sampling using a statistician, or non-statistical sampling, where the claimant selects certain samples from the many smaller claims, for which evidence is then taken, and a technical expert then comes back and opines on whether those samples are indeed representative for the overall population of claims, and the findings for these small claims are then extrapolated to the entirety of the claims, which is an efficient way of dealing with it. Then a more modern way would be computer modeling, where you can simulate certain scenarios and predict the outcomes, but that is a more sophisticated and costly procedure that may not be available. My favorite one is actually the Pareto principle. I don't know if anybody in the room has ever heard about Pareto, the Pareto principle. I'm sure our chair has, because Pareto, Vilfredo Pareto, was an Italian engineer, economist, and philosopher. And he lived from 1848 to 1923. And Pareto came up with the 80-20 rule, what we call the 80-20 rule, because it's very effective. And so the principle is that roughly 80% of the effects come from 20% of the causes. And applied to claims management, that means that a small percentage of claims might account for the bulk of the value. And when dealing with many small claims, this in a construction arbitration, this can work as follows. So the tribunal and the parties identify the high impact claims that make up for about 20% of the claims, but that have roughly 80% of the value, of the overall value. Then the tribunal and the parties prioritize the taking of evidence for those 20% of the claims. And then they apply the outcome on the remaining 80% of the claims, and extrapolation in a way, and then that usually leads to quite a just result that the parties can live with. So these were my initial comments on contractors' claims.
Thank you very much, Bernd. Now, before I have a couple of reactions to what you said, but something fascinating has happened, which is that we originally had 90 minutes for this panel, but then I saw there that started at 60. So that's on a construction project, that would be very interesting, right? I mean, so your time being cut by 33%, are we supposed to go through the same content? So I don't know whether that's an error or not. Maybe someone can tell me in the meantime. If it's not an error, we are on a very challenging acceleration program, I should say, because we had planned the panel on a 90-minute basis, and I checked the program is actually 90 minutes. So, but just so very quickly, one thing that I have done, for example, as arbitrator, maybe less scientific than applying the Pareto rule, but certainly if you have 50 claims or 60 claims or something like that, you can select the highest value ones and bifurcate the procedure. And you decide the high value ones. Now, personally, I haven't really then applied those outcomes to the rest of the claims. I think unless the parties agree, that would be extremely problematic. But then what I have found is that generally then the parties settle the remaining small claims that would take a lot of time, but they're probably not worth fighting too much. But given the acceleration program, maybe I turn to you, Bernd, again very quickly. For you to talk to us about the other side of the coin, the employer's claim.
Yes, this will be very brief. We usually, in the context of employers' claims, we talk a lot about delays and liquidated damages and penalties. But what's not so often talked about is defects, so claims for defective works. And I'm currently sitting as arbitrator in an offshore wind farm dispute, which is all about defects. It's all multiple defects or alleged defects, especially corrosion protection measures that were not in place, and substandard materials that do not meet the contractual requirements, and all of this resulting in a compromised structural integrity of the windmills. And there were two interesting aspects in this case. One of them is evidence. And sitting there as the arbitrator, we realized that how important it is for the employer to make sure to record any defects at the moment the project is being handed over to the employer. In our specific case, years have gone by. The employer did not apply the maintenance that it should have applied, and it is uncertain today whether certain defects were actually caused by defective works by the contractor, or if that's the result of the lack of maintenance. So that's, I think, one lesson learned. The other interesting legal question is, what are the claims that the employer actually has? So in that case, the employer has, if there's a defect, obviously, the employer has can demand rectification or compensation for the cost of rectification. But in our case, there's the interesting question of, can the employer also ask for an advance on costs for the rectification? Because as you may know from offshore wind farms, is that you cannot go there every day. You have certain slots. You have to rent vessels to go there, and it's not that easy. You can't just drive, and so it's more difficult to actually plan the rectification. There's certain rectification campaigns. And the question has arisen whether the employer can actually ask for an advance on costs. So that obviously depends on the contract, the applicable law, and the nature of the construction project. But that's an interesting question maybe some of you have come across. Thank you.
Thank you very much. And first of all, so we are adopting a slightly different approach. So I would like to open it up already for question from the audience, or comments actually, whether any of you, again, briefly, has any questions or views or experience in relation to contractors' claims or employers' claims. If not, then indeed we can move on to dispute resolution. So effectively, you have these claims that inevitably arise in relation to construction projects. The longer, the more complex the project, the more likely, unfortunately, that there will be then claims that are unresolved in one way or another. Now, I was having a conversation a few months ago. I mean, we hosted a conference for the 150 years of the Technology and Construction Court, and I was having a private conversation with one of the most senior judges in England and Wales, who shall remain anonymous, who told me at some point, Renato, you and I know that only stupid people litigate or arbitrate, right? But so we can say that most of us make their living out of people's stupidity. But I mean, the reality is that there are, deep causes and deep reasons why, inevitably, in one way or another, claims are there and are not resolved within the contractual mechanism. So first, however, when you have a claim that is not resolved entirely within the contractual mechanism, it is still very worthwhile to try and resolve it amicably before escalating it to arbitration or any other formal way of dispute resolution. And I would ask Paul to comment on that and share his views.
Good, thank you, Professor. If you are a Kenyan, we would be calling you Professor, since you have 2 PhDs, or at least Doctor. That might be your take home from Africa.
Generally, my African students, they call me Prof.
Ah, okay. Yeah. Good.
I can't persuade them to call me Renato or any other way, but it's quite, I find it quite nice, actually. I got quite used to it.
Incidentally, the Pareto principle, the 80, here we just call it, we call it 80-20 rule, applies in DBs, dispute boards, and in arbitration, because there have been lots of complaints about arbitrations being expensive. But actually, according to empirical research, arbitrators' fees, even when we have a panel of 3 arbitrators or DB members, amount to 15 to 20% maximum of the total cost. The lawyers on both sides take 40-40. So the rule applies. I am all for amicable settlement of construction disputes. The first time I attempted mediation of a construction dispute was like 10 years ago. I called 3 people who are friends of mine. They were experienced arbitrators and dispute resolvers, a QS, and 2 engineers. I had prepared a short list. And I called the first one and asked him, would you be available to be considered for mediation of a construction dispute? He said, no. But I said, you are a qualified mediator. He said, construction disputes are not amenable to mediation. So I called the second person on the list. I asked the same question, and the response was, Paul, don't waste your time. Just take your dispute to arbitration, because that's the mechanism which was in the contract. I called the third one in quick succession, and the answer I got was, hi, Paul, just follow the advice which my friends have given you. As it happened, my 3 friends were in one room. And they could overhear our conversation. Let me comment a bit about amicable settlement under FIDIC contracts. In FIDIC, the structure is engineer, reference of the dispute or the matter to the engineer, dispute board, and then after a dispute board decision follows notice of dissatisfaction, then amicable settlement, finally arbitration. So amicable settlement is placed between dispute board decision and arbitration, and I've always found that very weird for several reasons. First of all, I don't think you need to litigate or you don't need to legislate, as it were, amicable settlement. Amicable settlement can take place or should be attempted at every stage of a dispute. Before the DB, during the DB referral, before the arbitration, during the arbitration, amicable settlement is so versatile that it can and should be attempted at every stage. Then also, the provision of 28 days for amicable settlement, to me, does not make sense, for the reason that during the 28 days after the DB decision, before the notice of dissatisfaction, that is the period which is ideal for amicable settlement, because the DB has given its decision, each party knows its own case, and the other party's case. So this is a very good window before the notice of dissatisfaction. The other reason why I find the placing of amicable settlement a bit odd in FIDIC contracts is that notices of dissatisfaction are given, lots of them, as a matter of course. And then, instead of going to arbitration, the parties conveniently, somewhere down the line, abandon the arbitration, which the notice of dissatisfaction is all about. I'll move to something else. I'll talk very briefly about two cases in which I have been involved and where amicable settlement has worked very well in construction industry. The first case was a dispute board. I was a member of a 3-member dispute board in an engineering dispute in a certain Central African state. After the dispute board decision was issued, one party did two things. It filed a notice of dissatisfaction, meaning the next stage was going to be arbitration. At the same time, it filed a judicial review application in the High Court. Now, a year later, the arbitration had not started, but the High Court had not given its decision in the judicial review application. So everybody was frustrated. I think the party which went to court had assumed that it would get a decision from the High Court quickly. But a year down the line, there had been no movement. In fact, the judge who had first handled the matter recused himself somewhere down the line. So we were on the second judge, and there was no indication that we were going to get a decision anytime soon. Now, the parties settled amicably, and the party which had filed a judicial review application withdrew it, so the case ended that way. So in that case, we see an engineer's decision leading to a dispute board decision, leading to High Court, and to amicable settlement. I'll tell you a little more about the second case, assuming we have time. Prof, please flag me down if I exceed the time. I have no problem
Go on,
with
very
that.
briefly, yes.
Yeah, okay.
2 more minutes.
Oh, 2 more minutes.
Generous.
Laughing is all I can do. Just enough time for an African laughter. Now, in this case, I was representing the respondent. By the time I was appointed, the arbitrator had been appointed, and Chartered Institute of Arbitrators Kenya branch was the appointing authority just before Jacqueline took over as chair. And CIAB had appointed a quantity surveyor who was a mediator. And I was very pleased with that because the dispute had many facets, but the principal ones were dysfunctional refrigeration equipment, and 2, a leaking reinforced concrete slab roof. So I thought that CIAB had done really very well to appoint a quantity surveyor. When I was appointed, I learned that the advocate representing the claimant was a qualified mediator. I also happen to be a mediator. I called him and said, you are representing a very reputable construction company in Kenya. I'm sure your client will be very happy if you resolve this matter out of court. And I'm sure he has many disputes to refer to you. You will not miss the fees. So he asked me, why are you making such a proposition? I put my cards on the table. I said, my client is a foreign company, completely new in Kenya, in Africa. It's based in Germany. Any minute, the CEO and the board of directors spend discussing this dispute, is time taken off their core business. They are in the hotel industry. That's what they do best. They have done it for years in Europe and the US. In Kenya, in Africa, they are new. They really want to concentrate on their core business. So he asked me to suggest names of 3 mediators. I suggested 3. And, he chose one. I asked him, why did you choose that particular one? And he said, he is an excellent mediator. He is an advocate of the High Court of Kenya, but he is an excellent mediator because I happen to know because I have a dispute which he is mediating. I said, wow, that might be conflict of interest. We laughed about it, but honestly, in mediation, the standards are different. I had no problem with him mediating. So we mediated. After a few sessions, unfortunately, the mediation collapsed. And it was not the mediator's fault. It's not the party's fault. They had both of them given very generous concessions, but the mediation collapsed. After that stage, the party representative, who was an advocate of the High Court of Kenya, remember, I'm not an advocate of the High Court of Kenya. I am from the built environment. We said, why don't we encourage the CEOs to meet? And the CEOs met. A couple of times, they were unable to settle. The party representatives now suggested, let's give it one last shot. We meet the company directors, that is the CEOs. We meet the CEOs and the party representatives. We met in Westlands, in a Westlands hotel, not far from here. And the parties themselves reached an agreement within 30 minutes. The party rep and the other party rep and myself were told to go to a certain table to draft the agreement. I drafted a one-page agreement. The parties approved and signed, and that was it. Now, here we see a de-escalation of a dispute from arbitration. Actually, the statements of claim and defense and reply had been filed by the time we reached a settlement. So we are talking of a de-escalation from arbitration to mediation, and then from mediation to negotiation, which led to amicable settlement. Do I have a minute to make closing remarks?
30 seconds.
30 seconds.
I don't like to interrupt people, but yeah, I mean,
okay,
really,
thank you.
If you can just conclude.
Okay, now I'll not laugh. I have heard that Kenya advocates generally obstruct mediation. It has been a very popular complaint in Kenya. My own experience is different. It's that advocates of the High Court of Kenya are cooperative and very supportive when it comes to mediation. 2, the view that mediation is suitable for family disputes and succession matters only and not for commercial or construction disputes or technical disputes is not correct. 3, in Kenya, our 11-year-old court-annexed mediation has been hugely successful on its own, but there is a spillover effect which we are reaping in other sectors. Parties and advocates have started embracing mediation as a way of resolving disputes. Number 4, never give up when you go to mediation. Even if the mediation fails, you could still attempt negotiation, it could work. If that doesn't work, and the only thing you get from mediation is an agreement to refer the dispute to arbitration, at least you have kept out of court. You have not left empty-handed. Thank you very much.
Thank you very much. No, this time you did keep to the 30 seconds, more or less. But I don't want to take any more time. I would have some comments, but I would like to hand over to you, Jacqueline, to take us into the action.
Paul has spoken about the negotiation, what we call the amicable settlement, as well as the mediation. And for purposes of construction, I think what I should also mention is that CIAB did a state of ADR study, and we found that amongst the disputes that are referred to us for nomination, at least 30 to 40% are construction related. And those are the ones that come in with the name, the tender. This is something that has to do with construction. There are some which also disguise themselves in other respects. So we do think that the incidence of formal dispute resolution within the construction sector is much larger than what the respondents told us. And we find that most of the disputes either come in as construction adjudication, either under FIDIC contract, or also there is a bespoke the public sector contracts. And we also have then the arbitration clauses within the private sector. And one of the things that I've noticed myself in the few years that I have been on the board of CIAB, and I'll say I represented CIAB in the National Steering Committee that came up with the National ADR policy that was adopted by Cabinet in March of 2023, and which has now been taken to Parliament under session paper number 4 of 2024. And one of the reasons why I feel very passionately about legal reform is because we still, as you look at the requests for appointments that are coming in, we still find pathological clauses. So the first thing I'll say is that in as much as the people in this room understand what construction dispute resolution entails, whether it's adjudication or dispute boards or arbitration, there are very many other people, and you can factor it to at least times 10, who do not understand what is really entailed. And I'll give you an example. Currently, I've been appointed as an adjudicator under a court order through the courts. The parties went to court and they adjudicated in court. They have an adjudication clause in their dispute resolution clause. And when they went to court, the lawyers argued on the basis of arbitration because for some reason people tend to use these two terms interchangeably, adjudication, arbitration. So when the orders came out, of course, the judge followed what the lawyers were submitting. So the court order said, we are appointing an arbitrator. But the contract says adjudication. When the parties came to appoint me, they appointed me as an adjudicator. And then we started the process of adjudication. We're thinking we're going to move very fast. Then the respondent says, I'm sorry, but the court directed that we appoint an arbitrator. So, of course, now is to ask myself, do I have jurisdiction? Have we followed the proper process? Am I going to continue with this dispute resolution and ultimately have whatever decision or award, as the case might be, overturned because it hasn't fulfilled the proper requisite procedural process? So that is a live case. What I've done is I've stopped the proceedings and I've told the claimant to kindly respond before the end of this week, so that we know whether we are continuing with an adjudication or whether we are, by consent, starting an arbitration. I don't know how this is going to work as we move out, but you see, pathological clauses, parties who do not understand the difference or the distinction between the different mechanisms, and then ultimately the challenge for you, the neutral, to determine whether I am sitting or you are sitting as a construction adjudicator or as an arbitrator. I think time will tell on this particular one. So that forms one of the reasons why I'm very keen to promote the policy, the National ADR policy, because the National ADR policy has a dispute resolution bill, now 2024, which speaks to mediation and conciliation and also creates an umbrella body and a disciplinary framework for working on it. And also, there's a construction adjudication bill and there's an arbitration amendment bill so that we can update ourselves with the international best practice and the standards that are being practiced around the world. So that is one of the areas that I feel pretty strongly about dispute resolution and how we can work towards making it a better space, particularly not where both parties are able to understand and appreciate the contracts, and they're complex. We have to accept that. They're complex, there are many, sometimes there are many multi-parties, there are multi-contracts, so even determining which contract is the one that will be reserved for a decision or a final award also has its own particular dynamics, and we do tend to see a lot of arguments coming in that particular space. I mentioned that sometimes disputes come to you and they are disguised. And what I've seen, and this I'll give another example, what I've seen is that, especially when it comes to technology, many of the disputes come to you as a contractual dispute. And as you now start looking through or asking the parties to frame their claims, you realize that maybe it's an IP claim, which is still sort of, which has its own dynamics. It could be an infrastructure claim, which also makes it quasi-construction. And if it is mega and if it covers, say, a whole country, or it covers or goes cross-border, then you find that you have to also apply and figure out how we're going to define construction disputes, how we're going to define them under construction adjudication or arbitration as well. So the example I have is a claim that came to me. It was a dispute between two partners and an IT contract. They were developing software. But when I started reading the contract, I realized they're developing software, but it is embedded in hardware. And the claim that they had was about, the claimant called it theft of key personnel. So the key personnel is what they were fighting over because the key personnel had developed a lot of the codes and the platforms and the applications that were going to be used. Ultimately, the key personnel was paid, so he said, bye guys, I've already installed for you whatever the software is, I'm out of here. So they are left with claims between themselves on who owns the software. Of course, ultimately, I was able to resolve that particular dispute, and they took it. I wasn't so sure whether they were going to accept it or whether they were going to challenge it, but they didn't. So I do believe that now this also then comes in with the other question of training. I'm a trained mediator, I'm a trained construction adjudicator, I'm also a trained arbitrator. And the truth of the matter is many of the skills that I use sometimes require that I become the mediator and speak to the parties and tell them, on this you need to agree. And it does sometimes take a while. So I think the other issue or the other aspect, which also ties in very well with my role, so I'm going to become a salesman here, is to recommend continuous training. When we come to the conferences, yes, we get to hear the practical challenges that others have faced. By the time they come to you, because the truth is, there's no construction dispute that is ever going to replicate itself the same way, with the same parameters, with the same dynamics. When it comes to you, you will have something new and special to think through and to resolve. So I, of course, first of all, start with CIAB. We train mediators, we train adjudicators, we also train arbitrators. I haven't just left it at that, and that's why you'll hear that I was professor's student. We sat through 1 week at King's College. It's actually a very nice environment. You really should go there. And we listened to industry specialists in different, from different backgrounds, even the delay experts. We listened to barristers. We listened to professionals in the built environment. We listened to Professor Renato, I think, and he was also, he worked very closely with Professor Nick Gold. And ultimately, by the time we completed that 1 week, and we work Saturday and Sunday, so be prepared to do that in summer, but I would want to recommend anywhere you have an opportunity to sharpen your skills, please do so, because that sometimes makes the difference between resolving a complex dispute well and to the satisfaction of the parties, or bungling everything up and creating an, I think this is called what? Litigation that is going to peter out maybe in the next 10, 20 years. I think I'll stop there because of the time. Thank you.
Thank you very much, and also thank you for this publicity for King's, which so, I mean, it wasn't agreed, and I didn't make any payments, underhand payments for this, but thank you so much. So just very briefly, we are going to move now to experts, and I'm going to turn to Rajat for that. But just one comment that I would make is that since we mentioned adjudication, and we mentioned also dispute boards, DABs, we have carried out a research at King's on adjudication, UK adjudication, so this can be different in other countries, but we found there that only about 5% of adjudicated decisions are referred further to litigation and arbitration. And we are carrying out, so this is not a completed project, but we are carrying out a project on dispute boards globally. So actually, and it's an empirical project, so if you haven't seen it or responded to the survey and you are involved in dispute boards in any capacity, please participate. We already have some preliminary data. We found, for example, the dispute boards are reasonably used in Africa. And for example, we did confirm that they are almost never used in the Middle East, but they are used in Africa. And in relation to dispute boards, we found similar figures, actually, that only between 5 and 10% of DAB decisions, maybe a little bit more than in adjudication in the UK, are referred further to adjudication, to arbitration. Sorry, and the other thing that I would say, I very much agree with Paul, that there is no set time for amicable settlement. Yes, you may have a clause that says that you have to try it at a certain stage, and you have to do it because you are obliged to do it, and it may be successful, but actually as counsel, external counsel or in-house counsel, or as CEO or the commercial person in charge of the dispute, I think you have to monitor the dispute all the time to see when it is appropriate to try something like mediation or amicable settlement, which almost always, I would say, could be a better outcome than arbitration or litigation. But now I would like to turn to Rajat, who very fittingly, given his role, will talk to us about expert evidence and the role of experts in dispute resolution.
Thank you, Professor. And I would like to mention that, as usual, we have followed very religiously the sequence. Experts come at last in the dispute, so as the panel discussion. So now talking about the role of experts, we have heard in past 2 days that how there are different stages of a dispute resolution, and in each stage now the experts have now been involved and engaged. So what does an expert do? First, the meaning of expert is that he is a subject matter expert, and it should be technical, usually technical, not should be, it is usually technical, and the role of a technical expert is to disentangle the complexities of a dispute. Of a technical matters, maybe those are engineering issues, construction issues, or some quantum cost issues. So now, what does an expert do? The expert provides an objective assessment to the evidence available in the proceedings or in the dispute. By saying objective, I would try to explain it via 3 examples, which Dr. Byrne has actually reflected upon, and the dancing with disruptions. So he said that in disruptions, there is a very high bar of burden on the contractor. He has to maintain a comprehensively detailed daily records to prove his claim on disruption. But there is a catch in that. You cannot expect a contractor to have an army of quantity surveyors or record keepers at the site, because disruption is a claim which is related to the activities. It is not related to time. And there are so many numerous activities going on site at a same time. You cannot expect a contractor to put an army of quantity surveyors. So what I encountered in one of my assignment was that, and usually the respondents or the employers take advantage of this, I would say, lacuna in the record keeping. So the contractor submitted a loss of productivity claim measured at a weekly basis. He was keeping to that granularity. But the respondent rejected that claim, saying that you should have kept the records to the daily level. So, and the expert from the respondent side also resonated with that thought. But the claimant's expert, what he said, obviously he quoted Keating, which says that you cannot just preclude a claim by saying that a daily productivity is not there. If the disruption is apparent, you should calculate it. That is why SCL provides numerous methods to calculate loss of productivity. If it was an absolute method that you have to calculate productivity on daily basis or hourly basis, there would have been only one method. So the experts should not overlook common sense just by abiding to they can't be so harsh. They have to provide an objective assessment based on the evidence available to them. They cannot ask the parties to create some new records because experts come at last. They cannot ask the parties to create some new contemporaneous information. That doesn't make sense. And to put an example to that, let us assume that on one day there was delay in delivery of the materials. Because of that, there was no work at a particular location for that particular activity. So there was 100% loss of productivity for that particular activity. But the next day, there was 200% of productivity achieved. If I merge these 2 days, the net work done was equal to the plan with the same manpower. My disruption would be 0. But if I measure it on daily basis and the contractor is trying to claim only for the days for which he lost the productivity, then it will not make sense because he is paying the workmen usually on monthly basis. So in a project, let us say, which is spanning for 50, 60 months, a large you cannot ask a contractor to maintain a daily record and put a claim according to that. So you have to put some sense into it. There may be a situation you may have to calculate the disruption claim on a monthly basis or a weekly basis. So that is one thing. The other thing I would like to expand on that Pareto principle on 80-20. What I'm going to say is not exactly but the Pareto principle, but in sampling also, there is one method which is inspired from Pareto principle. Let us assume the quantum expert has to sample or basically audit the time-related cost for the project to make the cost profile. The project spans for 36 months. The 26, in sampling, what a quantum expert would usually do, he would sort the cost of each month in a decreasing order and then take the top 20% months. Not in terms of value, in number of months. So 20% number of months of 36 total months would be 7.2, let us say 8 months. And you will notice in most of the cases, these 8 months will comprise 70 to 80% of the cost. So it may look that you have taken a sample set of 20%, but actually you are auditing the 70, 80% of the cost. So that's one way of sampling. That's where the expertise can actually help and reduce the task for the adjudicators or the decision makers, and also help the stakeholders to actually look or objectively look on the claims and to defend the claims. The third example I would take from a delay perspective. And the experts are usually challenged in arbitration that they are interfering with their duties and they are actually entering into the boundaries of contractual interpretation or legal interpretation. So I remember the speech by engineer Wangi yesterday, where he said that the standard forms of contract by FIDIC are meant to be administered by the engineers who are actually working at site. So it is actually true. The lawyers come at very last. They can actually make multiple interpretation of a single word, and that single word I would take as an example would be unforeseeability. That's a legal concept. Definitely that's a legal concept. But how does it applies to engineering? Let us say in one contract, there is a excusable event for unforeseeable rainfall. And the delay expert identifies that there was a delay due to rainfall. Now, whether this rainfall was unforeseeable or not, some say that it's a legal matter. But I would say that is not, because an expert can also pull up some statistics and say that this was the trend of rainfall in this particular region. These were the things. And he can interpolate or extrapolate whatever by whether that, and can give some objective anchor to the unforeseeability aspect. So that's how the parties can actually use the experts. So having said that, do I have 2 more minutes?
Yes, you do.
Okay, thank you.
Let's say 1.5. Yeah.
1.5, okay. I won't delay that. So having said that, so selection of an expert is actually important. And there are some certain objective criteria from which you can actually select or sort down what kind of expert actually do you need in your, for your dispute. Those criteria could be his practical experience and the professional experience and the region where he actually practices. And the region where he gained that experience is also important. How many testimonies he has given, and other thing which I personally feel should be seen, that if he is an expert on some particular subject, how he is contributing to the development of scholarship to that particular subject. Whether he's writing some articles to that, he's attending conferences to that. That's important because that reflects the flexibility of his approach and the objectivity of his, I would say, assessment while considering some facts, evidence, and the different nature of disputes he is going to handle. So that may reflect. So such kind of criteria are important in selecting an expert. And to close, sorry, I think I still have 15 seconds.
No, don't look at that, because I'm going to abuse my position as chair.
No, but you are a professor too.
And take at least 10 extra minutes, because I think we do want to do, to have perhaps some questions and some reactions. So, unless people take me by force, we'll stay here. We had until 5 p.m. on the program anyway, so I hope it's okay. So please go ahead.
So to close that, why I stressed upon that the region where the expert has gained his experience is also important. And that actually goes back to our theme of this conference, to building resilience in African construction sector. So I believe that the construction principles are similar throughout the world, but yes, the specific construction processes are dependent on the region where the project is being undertaken. So an African engineer who has gained 15 years of experience in Kenya dealing with a dispute here in Kenya would be much more efficient rather than a 30 years experienced European expert. I am saying this, he can be, but yes, you should also look that as a criteria for selecting an expert. And yesterday, many speakers actually said that there is a lack of local expertise in the dispute resolution forum in African landscape, but they also said that the collaboration is the solution. I would say it's an immediate solution which can be actually adopted, and this collaboration can actually help to develop the local expertise in African continent. Thank you. Thank you, sir.
Thank you very much, Rajat. Thank you. And of course, ACL is doing quite a lot in terms of building expertise with the academy, for example, which King's is supporting, as well as sending students, of course, to London, having many students to London, and we hope to be doing perhaps more things in Africa, so that people, either online as the academy or physically in Africa, so that people don't have to come all the way to London to kind of discuss with us and perhaps enhance their construction knowledge and construction skills, and we can learn from them as well, as we always do. One thing about experts that I wanted to because you commented on the evidence that you look at, and and sometimes experts do not have perfect evidence, and I think as an arbitrator you should understand that, and you should understand that of course whoever is defending a claim will always find holes in the documentation and in the evidence and in the records and in the methodology, etc. I have yet to see the perfect claim, and if you have the perfect claim, really even stupid people wouldn't litigate or arbitrate. One should hope. But I think one important thing that I think I would give as a piece of advice to experts and counsel as well, and from my perspective as an arbitrator, expert evidence should always fit with the overall evidence in the case. I'm not just talking about the evidence that the expert focuses on particular, the program and the schedules for a delay expert or the invoices or whatever, but the overall evidence, the contract, the witness statements, what actually happened, the story that the emails tell, etc. And I'll give you perhaps the simplest example I can give. Was an arbitrator in a case, and one of the issues was ground conditions unforeseeable. Well, whether they were unforeseeable or not, of course, that was the point. It was a structure that collapsed because of the geology of the ground. And the question was whether it was unforeseeable, was the employer's risk or the contractor's risk. And of course, you had expert professors, geologists coming to exactly the opposite conclusions, where that particular geological formation was foreseeable or not. But at the end of the day, this contractor had been working on the site for 24 months. They knew that there was a geological problem there. Yes, whether they could have foreseen those particular formations or not, but which evidence are you going to believe, right? I let you decide, but the expert evidence, experts shouldn't be plausibility magicians. Should be common sense based specialists that help the tribunal to get to hopefully the right decision. But I would like to open it up to the audience to see whether you have now any questions or comments. I think there is, we cover quite a lot of ground, from claims to experts to settlement, arbitration, dispute resolution, adjudication. I know you want to go for coffee, but yes, I see a question over there on the right-hand side. The microphone, please. A gentleman first of all over there, and then a gentleman at the back.
Thank you so much, Chair. I have a question. In highly specialized infrastructure contracts, is it always the case that the expert witness must come outside the organization that is, for example, claiming? Can an expert witness be an employee of the contractor, for example? And can they speak to these specialized cases in some of these specialized contracts? Or is it always the case that you are advisable to get an expert witness outside the organization? So for example, if it's, I'm thinking about...
yeah, no, that's clear, I think.
Yes.
Yeah.
My second quick question is, Mr. Ngodo, you spoke about where the contract provides for multi-layered dispute resolution and parties decide to go to mediation first. How do you ensure you guard, number one, against your strategy eventually when you land and when you end up in arbitration, so that you don't expose your strategy in mediation that you hope to use in arbitration? And secondly, in terms of evidence, so that the process is not redundant, you might end up, in quotes, litigating in mediation in terms of the evidence that you are producing in mediation. How do you guard against that to understand that this is mediation, the limit of the evidence that you can rely on during mediation,
so
that it's not redundant in
All right, thank you.
mediation?
Thank you very much. So Rajat, perhaps the first one, I think it's an easy question, but perhaps it depends.
Yeah. So there is a concept that you can actually differentiate between the experts. I would say you are asking whether the expert can come within the organization or within the parties that are the stakeholders of a dispute. Yes, they can, but they can be the witness, fact witness in the proceedings. And when you are opting, when the parties are opting for an independent expert, whether those are party appointed or tribunal appointed, then those have to come outside the parties, because then another Pandora box of conflict of interest and those things open. So when, surely, because I have seen that similar to a geotechnical dispute, that the claimant had a very renowned geotechnical consultant, which they were getting consultancy on the geotechnical designs, and in a way that was the employee of the claimant, and they produced him as a fact witness, fact expert witness. But the tribunal appointed expert, what he did, he used his witness statement as an evidence, as a guidance to form his independent opinion.
Thank you. And Paul, I think the second question was for you.
Thank you. The question is how to safeguard oneself in mediation so that one is not prejudiced when, if should mediation fail and the process ends up being in arbitration. Now, in mediation, people are encouraged to make unguarded disclosures, to tell the truth. Apparently, they tell the truth when they go to arbitration, so they want to reserve their positions. Now, one way of doing that is making sure that the person who is mediating is not eligible to be appointed the arbitrator. That is one safeguard. I know in some countries, the same person mediates and then arbitrates. I personally would never accept such a position, because if parties have made certain admissions in mediation, I cannot delete that from my mind yet. I'm told that when we go fully AI, I might be able to switch on a button here to delete what I had earlier. But we are not there yet. Now, the other safeguard is that in mediation, we do not generally have expert evidence. So if you have expert evidence, keep it for use in arbitration. So there are some little strategies one could use here and there to attempt mediation in good faith and to take part fully without exposing oneself should the matter end up in arbitration. Thank you.
Thank you very much. So I am told no more questions now, so I don't want to abuse it any longer. I'm sorry. We can continue the discussion over the break. But anyway, congratulations on the previous panel for being an all-female panel. Congratulations on this panel for being a living proof that you can have an acceleration program which is effective and works. I think we covered exactly what we intended to cover in about 25% less time, which is not bad. If all construction projects could be managed like that, that would be quite an achievement. So 2 more things I want to do. First of all, please join me in thanking the speakers in the usual way. Thank you. And also, actually, one more thing I would like to do is to thank the audience for having stayed after already almost 2 full days and yesterday's dinner, and the room is still full. So thank you very much to all of you for contributing to this conference.
And thank you to you, Professor Renato, and your entire panel. Ladies and gentlemen, please let's appreciate them with a round of applause. And in typical fashion, we do have something for you. However, before we do give you your awards, could you please stand at the center of the podium? We'd like to take a joint photo. And thereafter, we would like to give some awards. To give the awards will be Mr. Philip. Mr. Philip, if you could make your way to the stage. Ladies and gentlemen, a hand for Philip as he comes up. Let's come to the center. in true fashion, we do believe in awarding ladies first. So our first awardee shall be Jacqueline Waihenya. Ladies and gentlemen, a hand for Jacqueline Waihenya. After Jacqueline shall be Dr. Bernd L. Ladies and gentlemen, a hand for Dr. L, who even despite having an injured leg, saw it fit to come. I think he really does deserve a louder round of applause, isn't it? After Dr. L, we have Mr. Paul Ngodo. Ladies and gentlemen, a hand for Paul Ngodo. Thank you, Paul. Let us appreciate our next awardee, Mr. Rajat Singla. Ladies and gentlemen, a hand for Rajat. And last but not least, an award for Professor Renato Nazini. Ladies and gentlemen, a hand. Ladies and gentlemen, as they exit the stage, please exit them with a loud round of applause, please. Thank you. Now, before transitioning to the next panel, I believe you've been seated for far too long, and I don't think it's very healthy. We need to get your blood circulating. So there's an exercise we had attempted to do a little bit earlier when the room was a bit sparse, but I think right now we have critical mass. And I have been giving you opportunities to network. But now I want to make it a little bit different, and please, let's stick to a 5-minute timeline, because getting you seated back in your seats has been a bit difficult after giving you opportunity. However, it's important to know who is in the room. So, how many of you were born in January? Let's just see how many of you were born in January. All right, how many of you were born in December? December hands, okay. So those of you born in January, look for your counterparts born in December. So, we're going to match you up based on when you were born. All right, how many of you were born in February? How many of you in the room were born in February? Let's see any February babies. Great. And then how many of you were born in November? Any November people? Yes, we have some November people. So February and November, pair up. How many of you were born in March? Let's see the March people. Great. And then how many of you were born in October? Let's see the October people. All right, so March and October, pair up. And then how many of you were born in April? Where are the April people in the house? Great. And then how many of you were born in September? All right, so April and September, pair up. And then how many of you were born in May? Where are the May people? All right, we have some in the house. And then how many of you were born in August? Where are the August people? All right, we have an August baby here. You'll be the center of attention. So May and August, pair up. And then lastly, how many of you were born in June? I was born in June, so I can put my hand up. All right. And then how many of you were born in July? All right, there's July. So June and July come together. So everybody up, look for your birthday counterpart. So January, December together, February, November together, March, October together, April, September together, May, August together, June, July together. So look for the corresponding person to the birthday months. August is looking for May. So in your groups, one of you, take out your phone, do a selfie, hashtag ACL 2024. How you have met your counterparts from different months. It's more than just about business. It's more than just about solutions. It's getting to know the people that you're with. So come on, take out your phones, do a selfie, hashtag ACL 2024. You can post it on Twitter. You can post it on, oh, it's X now. You can post it on Instagram, Facebook, LinkedIn, particularly LinkedIn. Let's show the world that we were at ACL 2024, Africa Construction Law Conference 2024. This is a one time if you want to come and do it on the stage. Feel very free to come to the stage as a group. All right, ladies and gentlemen, let's take back our seats. I believe we've stretched. We've gotten to know who's in the room with us. More importantly, we know when someone was born, the month, not necessarily the year. So let's have our seats in 5, 4, 3, 2, 1. Let's commence. Please, let's please take our seats. We don't want to take up too much time about the next panel. We don't want to eat into their time. We want to engage in an Oxford-style debate. And what a debate we have ahead for you. We have 3 panelists, a chair and 2 co-panelists. I think as our platinum sponsor put it, we are in the graveyard shift. So I guarantee you this is the last panel. This is the last conversation we're having of the day. And thereafter, you're free to mingle, take a few cards, generate some business, offer some solutions for Africa. So let's all have our seats so that we can engage with our last function of the day. Ladies and gentlemen, please take your seats. We would like to commence with the last segment of the day. So maybe just to center us, let me ask if you can hear me. Please clap once if you can hear me. Please clap once if you can hear me. Please clap twice. Oh, Mary, you're in the room, but you're not listening. Clap once if you can hear me. Clap twice. Now, please, let's take our seats. I believe we have interacted sufficiently. We shall have more sessions to interact. Now, ladies and gentlemen, I would like to usher us into the last formal segment of today. We are going to have an Oxford-style debate because this House believes that liquidated damages clauses are a fair and efficient way of allocating risk in construction contracts. Now, to lead us through this very informative debate that we're going to have is the chair, Philip Bliss Alika. He is a barrister at Tanfield Chambers, London, in the United Kingdom. His experience as an arbitrator is in dozens of arbitrations arising in and out of sub-Saharan Africa in energy, construction, mergers and acquisitions, mining, security contracts, banking, carriage of goods, telecommunications, shareholder disputes, and publicly procured contracts. In 2017, he was appointed to the ICSID President's Panel and is on the Chartered Institute of Arbitrators President's Panel. He undertakes FIDIC, dispute board work, and is a CIARB accredited mediator. He is a contributor to World Arbitrator Reporter in Uganda and ICCA Handbook in Uganda, and Philip is designated to the UN CITRAL Working Groups 2 and 3 as a state delegate since 2017, and an occasional appointing authority under UN CITRAL rules. He holds degrees from Vanderbilt University and Leeds University. He has a diploma in international and comparative arbitration from Queen Mary University of London and a diploma in international construction contracts from Pantheon Assas, Paris 2. He is an independent, non-executive board director of Absa Bank and chairs the credit committee. Ladies and gentlemen, not necessarily for the last time, could we please put our hands together for Philip Bliss Alika. And he shall introduce his two co-panelists to lead us in this Oxford-style debate. That is Noella Lubano. Ladies and gentlemen, a big hand for Noella Lubano. And Noella shall be joined by David Kagwa. Ladies and gentlemen, a hand for David Kagwa. Over to you, Philip Bliss Alika.
Thank you very much. Ladies and gentlemen, thank you very much indeed for staying for the graveyard shift. It's very kind of you to be here. We have prepared ourselves for a titanic dispute. I was thinking of all the various metaphors that I could use to stimulate this audience so late in the day. But let me introduce the two contestants who are here to, one to propose and one to oppose this motion. But just before I do, allow me to just give a running order, just in case anybody has anything else that they might think that they want to do. Dealing with introductions, we're going to have the debate, both sides, or each side is going to have 10 minutes to propose and oppose. And then David will make his reply. He'll have 3 minutes. Noella will be able to respond to that. Again, 3 minutes. We'll then have a vote on the winner. And I'm pleased to say that I have brought a prize for that winner. And then I'd like to see if we can just take a count to see how people genuinely feel about the motion. And then, of course, I will award the prize that I have, and then I'm sure the ACL will make its gifts. So that's the order of business. We should be through within half an hour. If I may, I'd start with Noella. Noella Lubano is a partner at Oraro & Company, advocates in Nairobi in Kenya. She specializes in dispute resolution and arbitration. She has over 14 years of experience, focus on international arbitration, asset tracing, recovery, commercial litigation, construction arbitration, shareholder disputes, and insolvency and restructuring. She's listed in Chambers Global 2024, which ranks her in dispute resolution and dispute resolution, well, that's a mistake, dispute resolution, as an arbitrator with clients, praising her diligence and client-centered approach. She's also a next generation partner in Legal 500 for 2023, 2022, all the way through to 2020 rankings. She's recognized for her responsiveness, research skills, and approachability. Noella is featured in the Legal 500 Arbitration Power List, Africa 2023, and was named one of Africa's 30 most promising arbitrators in 2022 by the Association of Young Arbitrators. Noella holds an LLM from the University of Cape Town, an LLB from the University of Nairobi, and a postgraduate diploma in law from the Kenya School of Law. She is an accomplished speaker, sharing legal insights globally, including the UK and Australia. And if I may interpolate, she has got a wonderful sense of humor and a Goliath intellect. You know where that's going, don't you? But thank you very much indeed. So that is Noella. David, it's coming. David Kagwa is an arbitrator and a construction lawyer with over 18 years' experience in representing clients in resolving complex disputes involving major infrastructure and construction projects. He's the chairman of the Chartered Institute of Arbitrators Uganda, a senior partner at Kagwa and Kagwa Associates, a law firm specializing in international construction law and international arbitration. He has acted as counsel and arbitrator in several construction-related arbitral disputes brought under the major arbitration rules, such as UNCITRAL. David is a fellow of the Chartered Institute of Arbitrators, a fellow of the Institute of Construction Claims Practitioners, and a holder of a Master of Laws degree, a Laws degree in Construction Law and Arbitration. And I'm not sure whether or not David is going to be a gentleman or use his slingshot to meet Noella's arguments. But ladies and gentlemen, those are our two opposing sides. David is going to propose the motion. Noella is going to oppose it. And the motion, of course, is this House believes that liquidated damages clauses are a fair and efficient way of allocating risk in construction contracts. I'll just read that again. This House believes that liquidated damages clauses are a fair and efficient way of allocating risk in construction contracts. 10 minutes, David. Thank you very much indeed, ladies and gentlemen.
Good evening, all. Thank you, Philip. So I'm proposing that liquidated damages clauses are a fair and efficient way of allocating risk in construction contracts. I'll start by defining what liquidated damages are. They are a pre-agreed fixed sum to which the contractor is liable to pay the employer should it fail to complete the works by the time for completion. FIDIC refers to liquidated damages as delay damages, which is the amount stated in the contract data, which shall be paid for every day that shall elapse between the time for completion and the date for completion of the works or section. So these are the principles and why this motion should be supported. There must be a contractual clause allowing a claim for liquidated damages, and this ensures certainty. You'll hear from my land friend, Noella, saying that some of these clauses are unfair. There's nothing unfair about what you've agreed to and signed. The contract must state the time for completion when a certificate of practical completion ought to be issued by the engineer. Now, the word there is time for completion. Time for completion is that time or date which has been agreed at the commencement. So there's no surprise here. Both parties know that the project is going to last 18 months, and the last day of the project is 31st December 2025. There's nothing unfair about that. The contract must have a mechanism for extension of time to avoid time being at large. You will definitely hear from my land friend that there are challenges with every construction project. It is correct there are challenges, but if there is a challenge and you're not responsible for that challenge, make an application for extension of time, because the time for completion is not cast in stone. It's extended as and when you deserve extension of time. The contract must include a mechanism for the computation of liquidated damages. This is agreed at commencement. It is even capped. Liquidated damages can be 10% of the contract sum, and there is a mechanism of computing it. It can be 0.05% of the contract sum per day from when the damages are due. Under the FIDI contracts, there is a requirement that the employer, before they get entitled to these delayed damages, they issue a notice. So you're being warned in advance that you're going to pay these liquidated damages, though you know that you're already in breach. So are they fair? Absolutely. Freedom of contract is the bedrock of construction contracts. Parties sit and agree to these terms from commencement. They must be bound by these terms. The ultimate purpose of liquidated damages is that the parties agree from day one of their relationship of a fair and reasonable estimate of the damages that might otherwise be difficult to calculate. Now you can imagine most standard contracts have 3 layers or even 4 layers of dispute resolution. There is a decision of the engineer, which is the determination, and then there is a decision of the adjudicator, and then there is arbitration, and then most likely there is court that is going to enforce this arbitral award. Now you imagine if you had to take a liquidated damages claim through that entire 4-tiered system, it would be too expensive for the parties. So it's a very important aspect that from day one you agree on the cap, the method of computation, so that you don't have to go through this expensive process of hiring experts, of having to pay an adjudicator or a panel of arbitrators and having to go to court to make this computation. So it's a shortcut. Without paying any lawyer, without paying an expert, both parties know what will be paid in the event that there is delay. A liquidated damages clause benefits both parties. It benefits both the employer in a sense that they absolutely know what their compensation will be, so there are no surprises. Secondly, it benefits the contractor in a sense that they know the maximum amount of money they will pay in case of delay. And as we know, usually when the cap is reached, the employer has a right to terminate. So the mere fact that you know what will happen to you in case you don't finish, you're absolutely sure of your extent of liability. Most importantly, liquidated damages safeguard the employer's legitimate interest in having the project completed. If any contractor was at large to do whatever they want, for whatever period they want, they would never finish. But because they know that they will compensate the employer in case of delay, it safeguards the employer's interest. Of fundamental use is that they are very easy to collect. One of the most difficult things is debt collection, for some of you lawyers who engage in debt collection for banks. But the fact that liquidated damages can be collected at the time when you're computing the final account, it will be basically a question of computing how much money is due to the contractor. And then because there is already a pre-agreed method of computing these liquidated damages, you deduct it from the final account. So for basically those reasons, I invite this House to make a finding that liquidated damages are a fair method of allocating risk in the construction industry. Thank you for listening to me.
Thank you very much indeed, David, for that. We'll now have Noella oppose the motion. Thank you.
Thank you very much, Philip. Thank you for having me, ACL. I'm very happy to be here this evening, and I'm very cognizant of the fact that I'm the only obstacle between you and your evening. So I will try and make this brief and sweet. So the motion that I wish to oppose is that this House believes that liquidated damages clauses are a fair and efficient way of allocating risk in construction contracts. You've already been told that a liquidated damages clause establishes a predetermined amount of damage that the party in breach must pay to the other party as a result of a specified breach. The objective of this is to manage risk and the allocation of risks, which deal with uncertainties that happen when you're performing a project. I don't think I disagree that there is merit in having liquidated damages clauses, but I think the motion asks whether they are a fair and efficient way of allocating risk. And I want to submit to you that it is not a fair and efficient way of allocating risk for the following reasons. The first reason is that more often than not, the allocation of risk by liquidated damages is unfair because it can either be excessive or undercompensatory or punitive. And in those cases, it is not a genuine reflection of the loss incurred by the non-breaching parties. Indeed, courts have found that liquidation damages clauses that are not reflective of the actual loss that was suffered are not enforceable. Courts in the US, in France, in Singapore, and in the UK will set aside liquidated damages clauses that are punitive or excessive or undercompensatory. And in that case, I would say they're not always fair. The other thing that can be said is that liquidated damages do not take into account unforeseen risks. And we now live in the age of COVID, climate change, among other things, all of which are unforeseen risks. So in that situation, at the point at which the liquidated damages clause was being conceived, these risks did not come to mind to the parties, and therefore they were not taken into consideration. And in those circumstances, if you enforce it, or if a delay is caused by any of these reasons, would it be fair to say that the liquidated damages imposed are a fair allocation of risk when the risk was unforeseen? I say no, it is not. Liquidated damages do not reflect the realities of unequal bargaining powers between parties to a contract. More often than not, the developer or the employer has a higher bargaining power than a contractor. And in those cases, and especially when you're dealing with public contracts, there is a real risk that you will tender for a bid which has a liquidated damages clause in a take it or leave it form. And so in those circumstances, the contractor is unable to negotiate on the liquidated damages clause, can it be said to be a fair clause in that circumstance when a public body tenders and it has a take it or leave it liquidated damages clause? I don't think so. My learned colleague has alluded to the fact that it's extremely expensive to litigate a liquidated damages clause, and especially when it's a contractor doing so. So that where you have a liquidated damages clause that is prohibitive or is unfair or excessive, it's really very difficult to litigate it, because when you weigh the cost of litigation against the possibility of reducing that liquidated damages clause, the cost is prohibitive. What then happens is the contractor is forced to bear what is an unfair burden or an unfair risk that it ought not to have borne, because it is unable to bear the cost of litigating an unfair liquidated damages clause. In that case, can we say that the liquidated damages clause is fair when we cannot litigate it because the cost of litigating it is disproportionate to the reduction that you will achieve when you try to litigate it? I think not. I think there are other alternative options to liquidated damages that are suitable and appropriate and more reasonable. There is no point in waving a stick when you can wave a carrot. If you intend to incentivize a contractor to complete the project within time, you can give him a bonus for early completion. You don't have to have liquidated damages for late completion. You also have the option of actually recovering actual damages. In those circumstances, I would say there are fairer ways of recovering your losses on account of delay and of ensuring that your project is completed on time. The other issues that arise are what I call legal complications in the enforcement of liquidated damages clause. Firstly, if someone challenges a liquidated damages clause, the only way of you demonstrating that it is not disproportionate to the actual loss you have suffered is by proving your actual loss, making it clearly redundant for us to rely on a liquidated damages clause when I've already proved what my actual loss is. It really beats the purpose. Is there efficiency there, or do we see inefficiency? I leave it for the audience to answer. But quite apart from that, the other legal complications that arise from liquidated damages clause include where the loss is caused by a subcontractor who's performing a small portion of the project, and the main contractor has to bear liability for the liquidated damages. And the subcontractor will refuse to indemnify for the full sum of liquidated damages because he was only performing a very small portion of that big contract. A similar complication arises when you try to enforce it when there has been sectional performance. Why would the employer be entitled to recover the full gamut of liquidated damages when the project has been partly performed? He was to build 2 houses. He's built 1 on time. Why should the employer recover the full length of liquidated damages? Limitation of liability issues also arise, with some deciding to treat a liquidated damages clause as a limitation of liability clause, so that if it is struck down as enforceable, it doesn't mean that the employer doesn't have a right to claim damages. It just means he has to prove actual damages. But shall we cap these damages to the same level as the liquidated damages? What is the answer to that question? The courts have given various formulas, all contradictory. These are just some of the complications that arise. And so that my position is there's some merits in liquidated damages, but those merits do not conclude promoting efficiency and fairness. And I rest my case there.
Thank you very much.
Right on the button. Thank you very much indeed, Noella. David, your right of reply, 3 minutes, please.
Well, my land sister has stated that there is lack of equal bargaining power between the contractor and the employer. This is not correct all the time. As you may know, many of the infrastructure projects, like for highways or power dams or energy projects, you realize that the contractors are even more experienced than the employers themselves. That's why they take on EPC contracts. That's why they take on design and build contracts. They have large amounts of experience. You cannot state at any one time that there isn't equal bargaining power. But also, even if it were to be said, it will not have any place under the law. A person who signs a contract will not be allowed to challenge it on grounds of unfairness unless they can establish these 5 defenses. The first one, fraud. The second one, misrepresentation, duress, undue influence, and lastly, non est factum, or it is not my deed. My land friend hasn't raised any of these 5 to try and challenge the liquidated damages clause. So without it, it's a fair allocation of risk because the parties have sat and agreed that it will be sufficient. My land friend has also argued that it's a bit unfair, it's unforeseen, there are challenges with the contractor. We need to look at the basics. How does this relationship start? The relationship starts with an offer. The offer is the tender that the contractor sends to the employer. And in that offer, the contractor is actually telling the employer that I will execute all the works at an agreed price X, and I'll complete these works on this day, which is the time for completion. They are making a representation to the employer. It is them making them the offer. And then the employer accepts the offer at a consideration and actually pays the advance payment, pays the certified amount, and even agrees to pay interest in case of delayed payment. These are key fundamental elements of a valid contract, right from offer, acceptance, consideration. You cannot turn around and say it's unfair after you've made a promise that you've not fulfilled and you've been paid. It's for those reasons that I invite this House to make a finding that liquidated damages clauses are a fair allocation of risk in the construction projects. Thank you for listening to me.
Thank you very much indeed, David. Thank you very much. Noella, 3 minutes. Thank you very much indeed.
I will be very brief. There are jurisdictions, my learned colleague, where the courts are willing to set aside contracts that are influenced by economic duress, another name for unfair bargain, or unconscionable or onerous clauses. And therefore, we don't need to meet only those 5 vitiating factors of setting aside a contract before we can try and challenge a liquidated damages clause. It's still open to us in some jurisdictions, including Kenya in very limited circumstances, to argue that that clause amounted to economic duress or was an unconscionable bargain or is completely onerous. I do agree that when parties sign agreements, they agree to the terms of that agreement. But at the point at which they are agreeing to those terms, there are unforeseen circumstances that do not bear. And therefore, surely, a party should be entitled to depart from a liquidated damages clause that is influenced by delay caused by unforeseen events, such as the physical terrain that was unforeseen, that you would need to drill further down the foundation than you expected, COVID-19 issues, and also things such as climate change, including the recent floods that happened in Kenya that caused immense delays. That was not foreseen. And surely, a party should not be allowed to enforce liquidated damages clauses when those events have happened that were never foreseen by either of the parties. That is all that I wish to state. And I still repeat, they're useful, but they are not reflective of a fair or efficient way of allocating or managing risk.
Thank you very much indeed for those arguments, Noella and David. Ladies and gentlemen, we are now going to have a vote on who we think is the winner of the two debaters. If I can just on a show of hands ask for those who think that David, who was proposing the motion, was successful. And Noella? Oh, well, I think Noella wins. Well done. Thank you all very much indeed for that. On that basis, ladies and gentlemen, I'd like to present Noella with this prize. I'm not sure she'll be thrilled by it, but there it is.
Thank you very much. Thank you very much.
Thank you very much indeed.
And thank you very much for voting for me. Allow me to say this. I actually believe liquidated damages are a fair and efficient way of allocating risk.
Well, she's just been awarded a prize of Jenga. For those who know Jenga, it's derived from the infinitive kujenga in Kiswahili, which means to build, so construct, so she can do that. We did think about giving you the one that has the shot glasses, but in the end, we didn't know whether you consumed alcohol. Just before we finish, ladies and gentlemen, I just wanted to just find out, Noella has confessed, but I wonder whether or not others share her confession, whether or not we all agree that the motion is the right approach that we should have. Again, on a show of hands, who would have been in favor of the motion in proposing it? That is that liquidated damages are a fair way of allocating risk. Thank you very much indeed. And those who think it's an unfair way of allocating risk? Right, well, clearly the proposers have it. Ladies and gentlemen, thank you very much indeed for staying. Thank you very much indeed for your attention. Noella, thank you very much indeed. David, thank you very much indeed for staying. And to the organizers, thank you very much indeed for having us. It's been a fantastic conference. It's been nice to see everybody. Thank you very much.
It's okay. Ladies and gentlemen, one last round of applause for our debaters. We would like to appreciate you. Of course, we thank you for the contributions that you have made. If you could just stand in the middle. Gentlemen, if you could bookend our lady debater today. Stand on both sides, bookend her. And if you could have Matthew Walker walk up to the stage to give them the awards. Ladies and gentlemen, a hand for Mr. Matthew Walker as he comes up. Now, we do have a few things for you and would like to appreciate you. We would like to appreciate Mr. David Kagwa. Ladies and gentlemen, a hand for David Kagwa. After David, we would like to award Noella Lubano. Ladies and gentlemen, a hand for Noella Lubano. And last but certainly not least, we want to appreciate our very key moderator, Mr. Philip Bliss Alika. Ladies and gentlemen, a hand. Ladies and gentlemen, a hand for the panel as they retire back to their seats. Thank you. We are almost there. I'm starting to feel like a Kenyan politician. You know, they always say, "Nakwahayo machache," and then never comes, yeah? But I would like to assure you, this is the real and then, yeah? I would like to invite Director Sekai Nyambo to give us her closing session remarks. And thereafter, I shall invite you to go home or to network first. So ladies and gentlemen, a rambunctious round of applause for Sekai Nyambo.
Good evening, ladies and gentlemen. You have survived 2 days. To you folks. It is indeed an honor to stand before you. Ladies and gentlemen, as we come to the close of this enlightening and highly engaging construction law conference, like I said, it is indeed an honor to stand before you to give these closing remarks. As we look to the future, it is clear that the landscape of construction law will continue to evolve. The insights and knowledge gained here at this conference will undoubtedly serve as a foundation for tackling the challenges ahead. Whether it's adapting to new technologies, navigating complex regulatory environments, or striving for sustainability, the discussions we have had here will guide us forward. Beyond the formal sessions, the networking opportunities provided a platform for forging new relationships and strengthening existing ones. Collaboration and the exchange of ideas are at the heart of the progress in our field. And I hope each of you leaves here with valuable new contacts and renewed sense of community. It would be amiss of me to fail to mention to you the ACL initiatives that have helped our organization to grow and to serve you within the construction law space. I want to start off with membership to the ACL. Question, please put up your hand if you are not, and I say not, a member of the ACL. Oh, wow. Oh, wow. So I see like well over 100 people. So I'm expecting in the next week or so that our membership will grow by the equal number of hands that I have seen here this evening. Become a member of the ACL and get access to the benefits of membership, including inclusion and access to the ACL directory, discounts on events, seminars, access to technical papers, and we have recently updated our platform, and we're really, really excited about this. And we will be offering a discount for anybody who joins from this conference. So we've got your details already. Just let us know. We would like to involve you in the things that are happening. It's good for us to communicate, it's good for us to network, and this is a brilliant opportunity and platform for us to be able to do that. So I encourage each of you that are not, and I scoured and I looked at your faces, so I recognize those of you that are not members. So we're looking forward to the growth in about 100, 150 members in the next week or two. The next initiative of the ACL is the ACL blog, which, it's a brilliant tool because it gives us updates on practice and legal developments in the construction law space across the African continent. We also have the ACLR review. I would encourage you to check this out, which is a detailed review of many aspects of construction law across the jurisdictions in Africa. And my colleague Yolanda Walker is heading up this initiative. So for the Kenyans in this room among you, you'll be happy to know that ACLR review was published for Kenya, and we give thanks to Aurora and company for their contribution to this chapter. And the Kenyan chapter can be found on the ACL membership portal. So you know what you have to do? You need to become a member to access the review. It is really a brilliant tool, especially for investors that want to have an understanding of particular markets within Africa. So according to the jurisdiction. So the work has been done, and we encourage you to become members and get access. Last but definitely not least, and this is a passion of mine, ACL training. It is a key objective of the ACL. We are seeking to encourage and foster construction law expertise among practitioners in Africa through capacity building and training. The idea is to grow construction law talent right here in Africa. I've often said, for those of you who are from Europe, just plug your ears. But I've often said, why do we need to go to Europe? We've got talent right here. Let us grow our talent right here. And we here at ACL are looking to do that. So we launched last year the ACL Training Academy to do just that. We offer in-depth courses. Last year we did a brilliant introduction to construction law, which looked at front-end transactional law, to claims, to dispute avoidance and dispute resolution. We offer seminars, webinars, and we will be launching masterclasses. Let us make use of this. If you are a member, hint, hint, joy, you will be informed of these things, and also we will keep you up to date through our social media platforms. So you'll get to know what's up and coming. Now, I just want to spend a few moments giving thanks. First of all, let me express my deepest gratitude to all our speakers and panelists and moderators and attendees who have contributed to the rich tapestry of knowledge and insights we have woven together. Your expertise, enthusiasm, and willingness to share have made this event a resounding success. And I just have to say, from a personal perspective, sometimes you go to conferences and you kind of slip out because, you think some are going to be a bit more boring than others. I have to say, every single session I have actually enjoyed. And we have had some brilliant speakers this year. So I'd like to give our speakers a rounding applause. You folks have been brilliant. Your contribution starring. Thank you so much. I would also like to extend a special thanks to our organizing committee, particularly our friends from Kenya. So I'd like to mention Sharon Aboro, Lillian Katinji, and Tabitha Rory. Their dedication and hard work behind the scenes have made this conference possible. We would also like to thank GeoVision Events and Logistics and their production team that is headed by George Afei and his team, who have been absolutely fabulous. They did all the setting up of all of this, and the IT people, thank you so much, and thank you for coping with our craziness every so often, last-minute changes. Thank you so much. You have been brilliant. I would also like to thank our designer, Joshua Robinson, who is all the way in Jamaica, from Studio Colors, for all the brilliant conferencing branding and all the marketing materials and videos that he has done. We have 19 sponsors at this year's conference and 16 supporting institutions. That has been brilliant. We want to thank you for all your support, which has been invaluable. We deeply appreciate your commitment to advancing the field of construction law on our beloved continent. I would also like to thank our advisory board members who have been able to make it to this conference. And we would like to recognize you. The first individual I've got on my list is Professor Renato Nazzini. Is he actually in the room at the moment? I think he's outside somewhere. He has been brilliant. Kwajo, thank you for your support. Dialgo, where is Dialgo? He's not in the room. Oh, there he is. Thank you so much. He has been so supportive. And we have a new member, Dr. Brandt. Thank you so much for your support and for being here this year. Thank you all to our advisory board members who have been able to make it, for your advice, your direct involvement, and continued support of the ACL initiatives. And to our ACL country reps, I don't know if they're in the room. I have Daniel. Where's Daniel? Anybody from Uganda? I need you to know that Daniel is your country rep for ACL. Right, not Kenya. Kenya's got their own representative. That is Tabitha. I don't know if Tabitha is in the room, but most of you, I think, know Tabitha. If not, we'll introduce you. She's your country rep. Reach out to her. And then we have South Africa. Thomas King, is he in the room? No? He was one of the panel members for one of the sessions. Thank you for spearheading the marketing efforts in your respective jurisdictions. Now, we have a special treasure within ACL, and her name is Busola Adesanya. All of you would have interacted with her at some point. When I say she has been instrumental to the success of this event, ladies and gentlemen, it would be an understatement. She has been wonderful. So would you please join me again in just giving a round of applause to Busola for all her hard work. You'll be happy to know that I'm concluding now. In conclusion, there is no question this conference has been very informative. The speakers were excellent, the networking was brilliant, and I must say, many of you expressed to the ACL team just how much fun you've actually had at this conference, especially last night. Even those of you who said you could not dance, I saw you shaking your two left feet and having a whale of a time. As we leave this conference, we are armed with new knowledge and renewed determination. However, our work does not end here. In fact, it begins here. I urge all of you to take the knowledge and connections gained from this conference back to your respective roles and organizations. Let's continue to build on the momentum we have created here, fostering innovation, collaboration, and excellence in construction law. Thank you once again for your participation. We are looking forward to seeing you at the next ACL events. And for those of you that are leaving Kenya, safe travels. And may the insights you have gained here today propel you toward even greater achievements in your professional endeavors. I can now say ACL Conference 2024 is now officially concluded. Thank you.
Ladies and gentlemen, I do not believe in adding more to what has just been said. I believe she has commended each and every single one of you for your great spirit of sharing, of collaboration, getting to know one another, and most importantly, just being here. A round of applause for each and every single one of you. So before I exit, I would like to teach you what is called the Karabando Clap. Say Karabando. So the Karabando Clap is just to appreciate you for being great sports. I mean, I can't imagine a 2-day conference which per day has been running for roughly 12 hours. And all of you are still in high spirits and ready to engage, ready to be part of the solution, and definitely ready to build resilience in Africa's construction sector. So we are hoping that when this particular conference is held next year, we shall be hearing of the successes of each and every single one of you. Allow me to get off the mic because I can't instruct effectively. But I guarantee you my voice is loud enough for everyone in the room, isn't it? So the Karabando clap goes like this. I'll say Karabando, you clap 3 times. 1, 2, 3. Karabando. Karabando. This is where it gets different. Then I'll say Karabando one more time and then you clap 1, 2, 3, 1, 2, 3, 1. Okay? So Karabando twice, 1, 2, 3, Karabando twice, 1, 2, 3. Then the last time, Karabando 1, 2, 3, 1, 2, 3, 1. And this is just to appreciate all of you for being amazing, all right? So let's go. Karabando. 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 You have all been great. Thank you for engaging me, and thank you for indulging me. So the media team has requested to have a last group photo. Now, because you're too many to fit on the podium, allow me to invite you section by section. But once your section has taken a group photo, please feel free to leave. So to my extreme left, so wherever I stand and stop, everybody to my left will come up, all right? So, group 1, this shall be group 1. From this table here, everyone comes to the table. So group 2, just get ready. You can still talk to your friends. I have been directed to say shortest in front, tallest at the back, yeah?